Right. Good morning, ladies and gentlemen. Welcome everyone to the 8th Conferences on International Coordination of Secured Transactions Reform. The Faculty of Law at HKU is truly delighted to host this gathering together with the United Nations Commission on International Trade Law and in partnership with leading institutions such as the International Institute for the Unification of Private Law, the International Financial Corporation of the World Bank Group, and the International Law Institute. This conference is more than just an event. It's a chance to build connections, share ideas, and strengthen the global conversation on trade and law in the new age of a re-globalization. We see ourselves not only as hosts, but as partners in creating a platform for academic and research, policy research, and a hub for global collaboration. I want to express my heartfelt thanks to all colleagues who have worked tirelessly to make that event possible, especially my colleague Giuliano and his team. Their dedication and energy have been the backbone of this conference. So welcome again to Hong Kong, and welcome to this community of scholars, practitioners, and policy makers. Let's make the most of the 2 days together, learning, debating, and imagining the future of secure transactions reform. With your permission, I would next say a few words about the fire disaster today. We're deeply saddened by the fire tragedy, one of the most devastating in Hong Kong's history. Our hearts go to all those affected, and we extend our sincere condolence to the families and communities affected. On that note, thank you for coming to Hong Kong.
Thank you, Dean Fu. Well, I would like precisely to start with a warm thanks to the Faculty of Law that actually supported this event. And I would also like to welcome you all. We're very grateful that you made it so far. Some are a bit closer, some are coming from afar. So we really appreciate that you are here. I am genuinely excited about hosting this conference here for the first time in the region, and in particular in Hong Kong at our university. This wouldn't have been possible without the coordination and the joint effort that with UNCITRAL and in particularly with Jay and Monica that actually have been supporting together within the joint network for supporting secure transaction law reform, this event. So it was a meaningful collaboration, a perfect example of how when we put policymaker, international standard setter together in academia, we can actually come up with something that can leave a footprint. I would also say simply that on behalf of the Asian Institute of International Financial Law, AIIFL for the friends, I'm pleased to see you here, and I wish that the next day and a half will provide a meaningful chance to exchange different perspective, different solution to present challenges. We are talking about secure transaction law reform, which will dive deeper in some very technical and sometimes probably esoteric concepts, but ultimately we are deciding, we are discussing, we are debating matters that will have a larger impact on society by enabling access to credit, enabling inclusive finance, and then ultimately also ensuring a sound and stable and equitable financial system. So without further ado, I thank you all, and then I pass to my colleague, Mr. Jae Sung Lee.
Thank you, Giuliano. As many of you know, but some people don't know, But the joint network for secure transactions was actually established about 4 or 5 years ago to actually foster coordination and coherence about secure transactions reform. That includes not only UNCITRAL, but UNIDROIT, the World Bank, the ILI, to promote best practices and harmonize standards in secure transactions law. Now, this Secure Transactions Conference is a little bit older than that in the sense that we are having the 8th conference this year. It is actually a gathering of a number of the experts in this area to discuss ideas, and this is why we're happy to chair. I think UNCITRAL is the chair of the joint network this year, and therefore we're happy to host the conference along with AIIFL. I hope I pronounced it right, and with the support of the Faculty of Law of the University of Hong Kong. We'd like to first thank immensely Mitsui for the support, also Giuliano and Candy for all of the logistical support that you have been providing to us, and also to my colleague Monica, who has been behind the preparations of this event. It would not have been possible without these people's work. So it's an annual gathering, the Secure Transactions Conference. It's a family gathering that coincides with the Thanksgiving that they're celebrating in the United States, to take stock of all the developments, to share ideas, and to discuss the way forward. And as you can see in the agenda, it reflects the growing importance of adapting legal and regulatory frameworks to a rapidly evolving financial landscape. The decision was taken by the Commission at the last session, which was in July of this year, that some further work would need to be conducted on how these kind of aspects would be reflected in the UNCITRAL text in the future. And that is why we're also hoping that this conference will be an opportunity to discuss these topics and see what we can present to the Commission next year. Of course, this is not the end. We also have a colloquium scheduled for February on this topic of secure transactions. We're hoping to also take benefit of you being here and having an expert group meeting this Friday. And we're also hoping to have an expert group meeting next year in the spring to actually present some sort of a very concrete possible future work for the Commission in the years to come. So with that, let's enjoy Hong Kong and let's enjoy the discussions. Thank you very much.
Good morning, everybody. Ladies and gentlemen, thanks for coming to Hong Kong and actually for attending and contributing to this conference. This is going to be fairly short panel. In fact, there is not even a moderator. I will be covering a little bit both roles. Ignacio on behalf of UNIDROIT, Gérardine Escolar on a video, and myself on behalf of the HCCH and me on behalf of UNCITRAL. We will just provide short update of the most recent, let's say, legislative activities in the area of secure transactions or relevant for secure transactions that have taken place in our respective institutions. I will just set the floor, starting with a few things about UNCITRAL. Actually, you have already, and then pass the floor to Ignacio. You've already heard from my colleague Jay, basically a few points on what UNCITRAL has done in the past 12 months. And when I say 12 months, I refer to the seventh, as I take as a starting point, the seventh conference on secure transactions that took place last year in Istanbul, more or less around this time of the year. Was probably 1 week earlier, coordinated on that occasion by ILI, that is part of the joint network on secure transactions. And since that conference, what has happened in UNCITRAL concerning secure transaction? Well, UNCITRAL organized colloquium in February in New York. And the title of the colloquium was Navigating the New Era of Digital Finance, the UNCITRAL Model Law on Secure Transactions and the Use of New Types of Assets for Secured Financing. And a number of you actually attended that colloquium. So actually, thank you for being there and for being here, and hopefully also for participating in the next colloquium that UNCITRAL will organize around those topics. The colloquium looked more or less, not more or less, actually, the colloquium looked at broadly topics such as reforms by states and international organizations in the area of secure transactions, digital assets and data, use of digital assets and data as collateral, climate finance, and also operations of secure transactions registries and best practices, and also trades and supply chain finance. One takeaway from that colloquium was that many jurisdictions are very well aware of the new opportunities and challenges new technologies is bringing to secure transactions. And so they are already adapting their legal frameworks to accommodate these new forms of collateral, or testing, creating sandboxes. So looking into this matter. Another takeaway was that future work, future legislative work at international level on these topics would certainly benefit from international coordinations. And so this applies to UNCITRAL and as well as other international organizations active in this in international law. The results of the colloquium were presented at the last commission session, the last session of UNCITRAL in July 2025. And as Jay was mentioning a few minutes ago, one of the conclusions of the commission was the importance for us, for UNCITRAL, to keep exploring the matter and to keep seeing whether, excuse me, whether there is a need to adapt, update the model law on secure transactions to meet these new challenges. So the idea of having additional another colloquium in February next year, as Jay mentioned, expert group meetings, etc., were all coming from this importance, from this need to further look and investigate. So that was one series of activities that as UNCITRAL Secretariat we have done. Organizing, co-organizing with the Faculty of Law, with Giuliano and his team, the 8th conference of the Joint Network on Secure Transactions. That for us is an important moment to continue our exploratory work, starting looking into the additional exploratory work that will take the form of the expert group meetings and an additional colloquium. In parallel, another aspect of UNCITRAL work that is also quite relevant for us is the work on exploratory work on digital platforms. This exploratory work on digital platforms also is stemming from commission decision prompted by the United Arab Emirates proposal and Spain proposal, and exploratory work that should kind of move forward initial exploratory work that UNCITRAL already started in 2018 and that resulted among other things, in the publication of a taxonomy of legal issues related to the digital economy. Digital platforms are getting increasing importance in our economy, and the digital work of the preparatory work requested by the Commission is about looking further into the matter and how UNCITRAL can contribute. And so we can anticipate that this exploratory work will look at topics such as evolution of digital platforms, characterization and interaction of platforms, contracts, general principles. In terms of secure transactions, what is the relevance for us? The relevance for us is that digital platforms play a role also in the creation of secured rights in digital assets. And in fact, the colloquium in February on digital platforms will be back to back with the colloquium on secure transactions. It will be 4 days in New York from the 10th to the 13th of February. 2 days devoted to digital platforms and 2 days devoted to secure transactions. Last but not least, I'm gonna mention 2 colloquia on digital payments and paperless trade that will take place in Vienna in January, 19th to 22nd of January. These other 2 colloquia will look into these aspects of digital payments and paperless trade. We're actually looking for experts who could contribute to the colloquia in Vienna. If you can provide such contribution, please contact me or Jay.
Okay, so good morning, everyone. I might start doing the same. I just came straight from the plane myself, so hope nothing happens to me. So thank you so much, especially to the Hong Kong University and to Professor Castellano and to the Dean for having us, for inviting us to speak in this conference. In my case, I think it's the 4th time that I'm invited in the past 7 years, so I'm particularly grateful for that opportunity, always in my capacity as a member of UNIDROIT. So this event is particularly important for us, and it's quite close to my heart, if I may personalize it a bit, because the idea of this meeting started several years ago, well beyond 5 years ago, when Chuck Mooney, Marek Dubovich, and myself organized a conference at the University of Pennsylvania to discuss coordination of what was mostly focused on coordination and technical assistance in insolvency rather than in secure transactions. But then it was evident that there was a strong need to coordinate the activities of the organizations also in secure transactions. And that's how it got finally institutionalized and is now institutionalized with a very stable governance, which we should congratulate ourselves for. I'd also like to thank UNCITRAL for the organization of the event, the co-organizers, and especially to Monica for her work and for her kindness, which is always excellent, and so much. So I see people in the room that I haven't seen in a while. I see Richard now in his body, because I have now become used to seeing an hologram of his in, on a computer. I see Murat. I haven't seen Murat in quite a few years. Still as much hair as always, but now whiter, which is a good thing, let me tell you. And I see many old friends that I also haven't seen in some time. So it really is great to see some of you. Charlie, has been a while, I think. So many of the things that UNCITRAL is going to explore, work on, have been already discussed and are in the form of a UNIDROIT instrument called the Principles on Digital Assets and Private Law. So I'm sure that this instrument will hopefully inform the discussion for that preparatory work that wants to be done. As to the status and prospects of the international standards in the area of secure transactions, I will say a little bit about what we have done in the past year. So it's merely an update of what we've done. It's been an important year for secure transactions at UNIDROIT. First of all, Cape Town continued to growth. Cape Town conventional international interest in mobile equipment. We are now at 90 member states, which is quite a lot, and 87 in the case of the aircraft protocol, which continues as strong as ever. Very good progress. We are now at numbers that we never thought we would see, with over 1.8 million registrations in the secure transactions registry in Dublin. That's a lot, with estimated value of collateral of over $1 trillion US, which is not something that one can say without marveling at it. We are also making very good progress on the rail protocol. Apart from new members of the family, we have now two things to announce. One of them is the very latest report of the Ministry of Transport of the Department of Transport of the United Kingdom, announcing the immediate implementation by regulation of the rail protocol. So it's going to be also a UK treaty very soon. And Spain, UK, and South Africa are three huge rail countries. So that's going to make a difference, we hope. South Africa, its export authority has issued a note according to which they would lower up to 20%, so doubling the Cape Town discount for those that for those exports to countries that have adopted the rail protocol. So that's quite amazing, doubling the original discount envisaged by the OECD for the aircraft protocol. MAC is making very good progress. We're just about to finalize the institutional documents. Negotiations for the contract are concluded. Our man is there, so he's very proud, and so are we of his work. As to the rest of the work, we've done a lot of recently in the past years work on secure transactions and access to credit for micro, small, and medium enterprises in the area of agriculture and out of it. Our model law on factoring and its guide to enactment are very successful already, have been incorporated in a number of countries, have been translated to many languages, to name a couple of them for obvious reasons, into Chinese and into Spanish, with great effort of Alejandro Garro and Teresa and others, Jorge and others. So we're very proud of that, and it's already been is enjoying widespread use and implementation in countries. Our joint work with UNCITRAL and model law on warehouse receipts, which is also has triggered a lot of interest in many countries, and that is also key in legal reform, especially in the area of agriculture. And there are two new projects I'd like to very briefly inform you about. You might not know about this. One of them is the new project will be starting at the request of the World Bank. We love working at the request of the World Bank because they have previously identified real needs on the ground in many countries. So we know that the instruments we produce will very quickly have a real life effect on the ground. And that is a model law bar legal guide still to be determined on investment-based crowdfunding. And that's something which we might be working together with IOSCO on the regulatory side, but we don't know yet. It depends, still to be defined, because our work program, which has been approved by the Governing Council, still needs to be approved formally by the General Assembly in a couple of weeks. This is non-controversial, so that will go through, but we will not start work until January. And finally, a project which has already been upgraded because it was there, it was a proposal from the government of the United States, which is a legal guide on agri-financing. And we're going to get together many of the existing instruments. We're going to do special work on the development and something which can be useful in crop receipts and other types of state-of-the-art instruments which can facilitate access to credit in the area of agricultural financing. This is fitting square with the work of UNIDROIT in private law and agriculture, for example, in the context of our work on contract farming, which is an extremely successful legal guide that we do with the Food and Agriculture Organization. So that's as much as I wanted to share with you from UNIDROIT's perspective. Thank you for being here. Lovely to see so many friends. And I very much look forward to our discussion in the coming days. Grazie ancora una volta.
Thank you, Ignacio. It's very interesting, a lot of interesting things on the plate. And of course, we look forward to cooperating together. And so now we do have a video from HCCH, from the Deputy Secretary of the Permanent Bureau.
Colleagues, friends, a very good morning to all of you in Hong Kong. It is a pleasure to join you at the 8th Conference on International Coordination of Secured Transactions Reform. I regret that I cannot be with you in person, especially as this edition is co-organized by the HCCH's sister UNCITRAL and on the theme of inclusive digital finance. I am, however, delighted to share with you some of the latest developments in the preparation of frameworks on private international law that relate to secure transactions reform. Let me begin with a scene that you will find familiar, as many of you are working daily with cross-border collateral structures. At a recent technical session, a senior structurer from a global project finance institution described a transaction that had been meticulously engineered, revenue streams linked to activities in international carbon markets, tokenized performance data feeding into a digital assurance platform, settlement obligations structured to operate through a cross-border digital platform pilot. Everything in the deal made commercial sense. And yet, the transaction stalled. Not because of credit risk, not because of valuation, and not because the parties were unwilling to transact. It stalled because the moment contractual rights and obligations, proprietary interests, and potential tortious liabilities interacted across jurisdictions, no one could confidently identify which court had jurisdiction over which claim, and therefore how the claim would be characterized, which law governed the proprietary effects of the collateral package, or whether a foreign judgment would be recognized and enforced where it needed to be. For those of us in secured transactions, this is not an anecdote. It is the daily reality of financing in the green and digital economies. And it is exactly where the HCCH's work over the past year has been quietly but decisively reshaping the international architecture that underpins secured credit. Now, across the HCCH's international commercial, digital and financial law or codified portfolio this year, one theme has been dominant. The perimeter and nature of collateral is shifting. Secure transactions now extend beyond traditional assets to include digital tokens, whose legal character often merges contractual, proprietary and restitutionary elements. Upstream, midstream and downstream positions arising from evolving carbon market infrastructures, CBDC-based settlement rights that may be governed simultaneously by the issuing central bank's rules, platform rules, and private arrangements, and data-linked entitlements whose misuse or malfunctions exposes parties to tortious liability. From a secure transactions perspective, this expansion is not simply about asset classification. It is about how different heads of claim, contract, property, tort, contract-adjacent tort, equity, interact simultaneously within a single transaction and across multiple legal systems. The result is a new set of private international law challenges. Jurisdiction over multi-layered disputes, questions about which law would apply, recognition and enforcement of judgments involving novel rights and infrastructures, and cooperation between courts and authorities in real time. These issues surfaced repeatedly in HCCH deliberations over the last year, and they now form the backbone of our ongoing work. I turn first to the HCCH Digital Tokens Project. The Digital Tokens Project has provided one of the clearest illustrations of how interwoven these categories have become. A token representing a payment obligation or a tokenized receivable gives rise to contractual rights. Once that token has been pledged or transferred, proprietary interests arise. If a validator fails or a node operator breaches a system's obligation, tortious claims may follow. And in a decentralized environment, all three types of claims may arise in different jurisdictions at the same time, or in a situation where it is not clear that there is an immediately obvious jurisdiction at all. Now, over the last year, the HCCH Experts Group on Digital Tokens has examined these scenarios after deciding to divide the deliberation into two work streams. The first work stream focuses on the elucidation of a private international law framework that will be fully aligned with UNCITRAL's model law on electronic transferable records, or MILITA. And the experts group decided just last week to proceed to the drafting of provisions for this future instrument. What is remarkable about this development is that it is a sterling and groundbreaking example of cooperation and coordination between the HCCH and our sister UNCITRAL, where UNCITRAL's standalone model law in its Article 19 leaves off work on private international law. This has now been undertaken by the HCCH with the full support and involvement of the Secretariat at UNCITRAL. The second work stream on the Digital Tokens Project focuses on digital tokens in general, relating to 1. Exclusively assigned data, 2. Stored electronically, and 3. Those with features that rely on decentralized mechanisms. The experts group on digital tokens focused their study on the grounds for jurisdiction and the connecting factors for the determination of the law applicable in relation to two concrete use cases, stablecoins and Bitcoin. In each case, questions emerged, such as which forum has jurisdiction when contractual claims, proprietary claims, and tortious system failure claims intersect? Can a court assert jurisdiction based on the location of a node, the domicile of the pledgor, or the place of control? What are the implications for recognition and enforcement if courts in different states categorize the token differently? This is precisely where private international law must provide stable connecting factors and predictable jurisdictional grounds. Otherwise, priority determinations, enforcement actions, and insolvency proceedings risk becoming unenforceable across borders. We turn then to the HCCH Carbon Markets Project, which has highlighted a different but equally significant challenge, the cascade of legal relations across upstream, midstream, and downstream layers. Upstream activities involve project-level claims, performance-linked entitlements, and verification processes, all of which can be structured into financing arrangements. Midstream movements involve registry transfers, adjustments, and multi-jurisdictional data flows. Downstream interactions involve settlement, reliance, and sometimes tortious claims linked to representations, disclosures, or failures in platforms or market infrastructure. For secure transaction specialists, the implications are immediate. What court is the appropriate forum to hear disputes that may arise, especially given the strong underpinnings of public policy and mandatory overriding rules of the carbon markets, whether in relation to Article 6 of the Paris Agreement or to the voluntary markets? How can safeguards, which are crucial to private international law frameworks, be inbuilt to ensure responsible scaling of the global markets? What law governs upstream entitlements, midstream registry movements, and downstream liability exposure? How will decisions relating to the carbon markets be recognized and enforced when in relation to a foreign jurisdiction? What international cooperation mechanisms are desirable in this emerging market? This past year's work has made substantial progress in identifying the connecting factors that truly matter across these layers, and, critically, in mapping where courts may legitimately assert jurisdiction for contractual, proprietary, or tort-based claims. The HCCH Experts Group on Carbon Markets has also focused on how rules relating to the determination of applicable law should be framed so that upstream rights determined in one jurisdiction are respected in midstream or downstream contexts. This is essential for responsible global scaling. Without coherent private international law rules, secured credit will not flow across the market structure. The Experts Group on Carbon Market meets next week to continue its deliberation on these matters. Now, our work with the HCCH Experts Group on CBDCs, or central bank digital currencies, has revealed how cross-border settlement assets reshape secured transactions analysis entirely. CBDCs introduce new proprietary constructs, balances that may be immobilized, pledged, or used within hybrid settlement systems. They create potential conflict between the lex issuance, lex system, lex contractors, and lex enforcement. And when operational failures or system outages occur, tortious claims may arise across jurisdictions. The HCCH Experts Group on CBDCs continues to examine scenarios such as the enforcement of a security interest by a court in one state over CBDC balances technically held in another competing state. What about balances or competing security claims asserted by creditors in different jurisdictions? They also consider tortious claims arising from CBDC platform outages affecting cross-border transactions. These cases highlight why jurisdiction, recognition and enforcement, and applicable law cannot be afterthoughts. If a court cannot enforce a proprietary order across borders, the secured transactions framework collapses. The Experts Group on CBDCs has decided at its last meeting to draft and issue an explanatory note detailing the private international law issues that arise in the cross-border holdings and transfers of CBDCs, keeping in mind the closeness of CBDCs to monetary sovereignty and financial stability. Across our work last year, one of the clearest lessons is that private international law is the operating system beneath secured transactions. It determines which courts have the authority to decide disputes, which law governs competing claims involving hybrid assets, whether a judgment will be recognized and enforced in another jurisdiction, and how courts and authorities cooperate to resolve cross-border conflicts. Without private international law, secured transactions reforms lose their international coherence. With private international law, they become scalable, enforceable, and reliable. And this is where the HCCH has focused most strongly over the last year, by quietly and methodically building comparative understanding, facilitating convergence, and crafting pathways toward future instruments. Of course, beyond rules, the HCCH has also brought something else to the table this year: cooperation. Our instruments are not only about choosing law or jurisdiction, they also create frameworks for judicial cooperation, administrative assistance, information flows between competent authorities, and recognition and enforcement that works in practice. As secure transactions increasingly rely on decentralized infrastructures, multi-layered market systems, and cross-border digital platforms, this cooperative dimension becomes indispensable. Without international cooperation, no state can manage cross-border claims involving contractual breaches, proprietary disputes, or tortious liability stemming from technological or operational failures. Cooperation is now part of the infrastructure of secured credit. And this is where the HCCH's long-standing expertise in creating international cooperation mechanisms is irreplaceable. So, what comes next? From the work of the last year, several pathways for the HCCH's future engagement have become clear. The Digital Tokens Project will begin drafting provisions for an instrument that will be complementary to UNCITRAL's Melita. The Digital Tokens Experts Group is also approaching a stage where mapping normative options on jurisdiction, applicable law, and recognition and enforcement in relation to digital tokens will become feasible. The HCCH Carbon Markets Project will continue refining upstream, midstream, downstream connecting factors and identifying the private international law rules needed for global responsible scaling. The CBDC's track will deepen its analysis of jurisdictional allocation, cross-border enforcement, and proprietary effects. And across the HCCH ecosystem relating to commercial, digital, and financial law, we will continue building coherence between the HCCH acquis and the emerging forms of collateral and liability. Colleagues, for a long time, secure transactions reform has been understood primarily as a matter of domestic law. But our work at the HCCH over the past year has made it unmistakably clear. The real test of secure transactions law is no longer about how it operates domestically, but how it performs when value, rights, and liabilities cross borders. Private international law shapes that performance, and the HCCH is building the foundation that will allow secured credit to scale responsibly in the digital and green economies. Thank you very much.
Welcome back from the coffee break, and thanks for being on time. As you see, sorry, I'm in this kind of karaoke mode. We have a very well-stocked panel for this opening panel 2, but it's actually the opening of the conference in terms of substantial inputs. As you can see from the program, the conference is starting, as it often happens for this kind of conferences, with a short, actually, with an interesting panel looking at the recent reform efforts across jurisdictions. We will hear from general perspective, two perspectives looking more at the region, the Asian region, but we will also hear from the experience of a country that is not at all in the region, like Uganda. So I will not take much of time to introduce in detail the panel. You will hear them. I will leave the floor, first of all, to Murat Sultanov, Senior Operations Officer at FIE. And we will have one of the speakers, the experts presenting, and you will see her, actually you are seeing her on video, presenting hybrid, Miss Miha Isoi, that is, who's a legal advisor at the International Cooperation Department, Research and Training Institute of the Ministry of Justice. Then we have with us Miss Angelia Chia, Senior Counsel at ADB. We also welcome Mr. Julius Cesar Parreñas. In his role as APEC coordinator of the APEC ABAC Asia Pacific Financial Forum. Ms. Stellah Kavezi-Olimi, actually Assistant Commissioner at the Uganda Registration Services Bureau, and Mr. Charles Booth, who's Professor of Law and Director at the Institute of Asia Pacific Business Law. And actually, Mr. Booth will speak after Miss Miha Isoi, since they are actually having a little bit of connection on the topics that we'll talk about. And with that, leaving the floor to Murat, please.
Thank you. Thank you very much, Monica. Good morning, everybody. It's really great to be back at our donor coordination conference on secure transactions. First of all, huge thanks to the University of Hong Kong, Faculty of Law, for hosting this conference this time, and all the organizers for preparing the program. I remember our very first donor coordination conference on secure transactions that took place in Pennsylvania back in 2017, so 8 years ago. And then, as I was just reviewing some of the older presentations that I put together for this event since I was preparing for this session, I looked up at the very first deck that I presented back then in Philadelphia. And I noticed that at the time in 2017, we were really sort of in the middle of implementation of the legal and institutional reforms across so many jurisdictions. I had all the slides, updating everybody on where we are with our reforms in Latin America, in Africa, in Asia. And it's interesting to see that now all these reforms have been completed. So we are in a place right now where we can reflect and take a look at what worked and what didn't work. Did it live up to the expectations, or what were the issues? So we can, and in this session, I'll try to sort of summarize some of the lessons learned from these reforms and assess to what extent they were successful or maybe not as successful as we were hoping. But before I speak about all these different jurisdictions across different regions, we should start by reflecting on the very first comprehensive advisory and technical support for secure transactions reforms that IFC have provided. And it started in Beijing exactly 20 years ago. So we've launched the very first secure transactions program with the People's Bank of China back in 2005, and this reform was implemented for about 2 or 3 years since then. It didn't start all that well, actually. The very first conference that we organized on this topic, a fairly senior government official basically made a quick intervention and said that taking receivables as security or using receivables in financing is not a good idea. It creates what he referred to as a triangle debt of sorts. So there was a lot of pushback from some stakeholders, but the People's Bank of China was really interested in this, and they thought that there was something in it that would benefit the market. So we started this project helping PBOC to make adjustments, very targeted amendments into the property law. At the time, they had a property law, I believe, and now it's been subsumed by the civil code. But there was a reform of the property law, a very specific amendments just to enable the use of receivables as a security, but also as a kind of a tool to attract financing. Whether you want to purchase them outright or whether you want to create some kind of security over receivables, this was enabled, because prior to this reform, simply receivables it was not possible to use them in financing transactions. And then there were a few other very specific changes in the law to allow general description of collateral and a few other important topics. And quite importantly, the central bank also launched the collateral registry. They did it fully in-house. We came and we actually did the demonstration of the registry that was in operation at the time in Cambodia. They took note, and what happened in several months, we came back and we've seen that this whole thing was already there. And it was done fully sort of in line with good standards of practice. So it's notice-based. It's very simple, didn't require for any specific additional information to be filled, was opened up for searches, open to public, et cetera, et cetera. And if you look at the law at this day, even at this point in time, if you assess it against the UNCITRAL principles, and by the way, that was obviously pre-UNCITRAL, right? So this was not just a model law, it was pre-legislative guide. But if you were to assess the legal framework right now in China against the main principles, we will find that it's not going to score a lot. It's still not unified, it's still fragmented, there's no functional approach. And yet somehow this specific changes really enabled the receivables industry to kick off. And so back in 2023, I think we've organized another study tour for some of our government officials in China, and the latest figures, I think they told us it's close to $10 trillion worth of financing against receivables, which it's really had a transformational impact on the financial marketplace in China, because these days pretty much every single bank, large and small, are involved in some kind of factoring, reverse factoring, and receivables-based types of programs. So so basically, one interesting sort of takeaway from this very first reform that IFC is implemented is that if the regulations and the law isn't really need to be all perfect, right? So you don't have to have a bulletproof, robust legal framework to create the market, but you need to have a minimal sort of viable legal framework, efficient collateral registry, and quite importantly, a big push from the regulator and creating the right capacities at the financial institutions level. So what I will mention, I will speak about several other countries as examples, and it's really all boils down to extent to which these three variables intertwine, which is, you know, the quality of the law and the registry, the regulator push or lack of such push, and the interest and capacities of the financial sector to really utilize these tools and create some new products. So from that standpoint, I wanted to reflect on a few more jurisdictions. One in Jordan and one in Uzbekistan. So in Uzbekistan, the reform was also implemented, I think almost 10 years ago. I think their collateral registry went live, but we have had several sort of attempts at legal reforms, because the first amendments in the law were, they approximated a little bit the legal regime in Uzbekistan to that of good standards, but not quite. So we had to come back and make some adjustments. And back in 2019, I think the last set of amendments were introduced in the civil code that really did create a functional approach. It allowed for, general description of collaterals, obligations, and enforcement systems were strengthened through out-of-court instruments and so forth. But again, 2 or 3 years ago, we went there to really assess what we've seen and speak to financial institutions, because we were considering launching a program with banks to help them design these new sort of modern asset-based finance programs. Collateral registry has been reporting excellent numbers, right? So for over a decade, they have had hundreds of thousands of registrations. People are doing searches on this registry. All kinds of transactions we've seen. There are leasing transactions, traditional pledges, sales of retained titles, and all those things. But when we actually looked at what banks are doing, in all these 10 years since the registry went live, we actually have not seen a single asset-based finance or supply chain finance program, which is something that that's actually one of the reasons why these reforms are being implemented, is really to help banks and non-bank financial institutions being able to design programs like purchase order finance, distributed finance, again, factoring, reverse factoring, and receivables-based types of programs. None of that existed. We're speaking to financial institutions, their mindset is still very much in the traditional space. They were telling us, why does collateral registry, for example, doesn't provide us with a list of sort of inventories that we can pick up and select? We actually do need to have a special fields to enter the numbers of invoices and so forth. So banks cannot wrap their head around the idea of even taking security right over present and future, let's say receivables or inventories without general description. So they still do things very much by the book. And all those notices of rights and movable assets, if you really sort of dissect these transactions, you see that there's still underlying real estate behind all those transactions. It just so happens that the banks also kind of grab everything else they can, including movable assets, and that doesn't mean that this is actually movable or asset-based finance programs. So, and trying to understand why that happened, because the laws does allow for this, right? So the law has been specifically designed to help these types of products to emerge. One thing that we've learned first is that the central bank actually hasn't been very active in this space. And Giuliano knows it quite well, because from the regulatory standpoint, both prudential, non-prudential, the body of these regulations was not catching up with the modern approaches. Banks are still asking a lot of questions about how one would go about, let's say, launching a reverse factoring. Actually, one bank that we approached 2 years ago was a large state-owned bank, SQB. They were interested to design this payables finance program, but the lawyers pushed back and they said, no, it's not possible, because reverse factoring is something that we're not allowed to do. So then we looked at and said, why wouldn't you be allowed to do that? Because reverse factoring is not a legal notion. It's not a term. It's just an umbrella. It's a kind of commercial name for a variety of legal instruments. So on one hand, you will have receivables purchase agreements, perfectly allowed. There's a factoring law within the civil code that allows you to enter in this kind of agreements. And then there's a master reverse factoring agreement between your buyer and yourself. What is the problem? They said, well, the problem is that we haven't seen this being explicitly mentioned in the circulars and regulations by the central bank. So this is then when we went to our colleagues in the central bank and proposed to them that we do need to provide some kind of clarity to the market that it's okay to do this kind of transaction. So, and this is what they've done. They actually have provided clarifications and issued some kind of circulars very specific to this bank. They've addressed their concerns, said you can do reverse factoring, and this is how you do it. This is what it is, and this is how you account for it. There were obviously some additional changes implemented. This actually was a joint project with the EBRD, Miltai. We've been working with the central bank in amending the civil code to align it with the UNIDROIT model law on factoring. Actually, these changes saw the light of the day several months ago, I believe this year in summer. The new chapter in the civil code on factoring was introduced. But most importantly, it was really the central bank's push to the sector to really incentivize financial institutions to do these types of transactions. And practically from the baseline of zero, I think the latest count we have is we have about $400 million worth of factoring transactions now in Uzbekistan, pretty much from the baseline of zero. So that has a huge market creation sort of potential. And the reason for it, not even the changes in the factoring law, because the law even pre-reform was already adequate enough for this types of structures, as we have seen in China, for example. But it was really the central banks and the regulators push that helped create that. Similar situation we have in Jordan, where also through a series of sort of protracted reforms, we had a number of attempts to amend the secure transactions law, but eventually we managed to get it right. The registry was launched. It's been in operation for 5 or 6 years, but because of the regulator hasn't really been providing a lot of push to the market. Again, financial institutions are not doing any of these types of programs and transactions. So we actually had the case for Jordan. We reviewed it very closely last year during our Istanbul meetings. And we've seen that, but unfortunately, even to this day, no single bank have launched any of the AIIFL supply chain finance products. We are, again, trying to push and work with the regulator, but they have not been as active as the regulator in Uzbekistan turned up to be in the last few years. So one other interesting example is that of the United Arab Emirates. And it really sort of interesting case because the regulator was completely dormant and not very active in pushing for these types of reforms at all. And yet the market really kicked off. And it did so because of the really good quality of the legal and institutional reform that's been implemented. A very active engagement from the Emirates Development Bank, which is the public development bank that have launched the supply chain finance platform. And quite importantly, the fact, and I think this is the main success factor, is that most of the banks are large global banks like Standard Chartered and HSBC and Citibank. They already know exactly how things are done. And so when this has been introduced onshore, because before they were doing it through the DIFCs, which is the Dubai International Financial Center, which is the offshore jurisdictions. But now this law has been implemented onshore in the jurisdiction. These banks have really started deploying these products also quite actively across businesses within the UAE. Final point I will make is that, so I was talking about these three sort of dimensions, right? So the extent to which the regulator is active, the quality of the law and regulations, and capacity of financial institutions. But now we're seeing another sort of pillar, which has been actually quite important already for the number of years, but becoming increasingly more important with the advent of AI, etc., and that is technology. So we are seeing also that technology is so critical because it also helps address some of the capacity gaps that may exist at the level of financial institutions. The banks in Jordan, when we talked to them several months ago, they do ask us about, why is that we still have some gaps, at the regulatory side was the central bank. That was maybe second or third question they asked, but the very first question they asked is, can you get us a platform, supply chain finance platform, so that we can start, launching this project? Because for us, it's a condition precedent. For them, it's the most important thing there is, because without the technology, you can pilot the program, but you cannot scale it up. You have to being able to do it with the full support of some kind of IT sort of underpinning that help you reduce the risks, that help you set the limits, and really sort of automate the process. So yeah, so technology is now becoming also quite critical, and that's the reason why IFC has been changing sort of its approach to our advisory programs, and we have done all these reforms in 60+ jurisdictions across the world. Very few programs are still focusing more on collateral registry and the law, but mostly now we are working with individual financial institutions and particularly helping them set up these technology solution, technology platforms, because this is really where the market is, and this becomes a critical success factor, an extent to which the banks will then be able to take the tools that were created to the law, the registry, and run with it. So I'll stop here and hand it over back to Monica. Sorry that I might have overrun my time.
Thank you, Murat. It was actually very interesting. Different examples, different reactions. So you always need somebody who turns the letter of the law in practice, so that you have some sort of successful reform implemented, not just on paper. Without further ado, I'm giving the floor to Miss Miha Isoi online. Hello, Miha. Nice to see you in person, although as an hologram. Can you hear us?
Yes.
The floor is yours.
Thank you very much. Thank you for the organizers and the facilitators to prepare the setting for me to speak online from Kathmandu, Nepal, where I am on a week business trip now. So, well, today I would like to share some little bit old story of Cambodia, where the coordination between the law on secure transactions and the civil code was a bit difficult. And I understand that the idea included in the secure transactions law is effective to reduce the risks and costs of financial transactions and to improve the access to finance. However, I would like them to at least be harmonized with the local legal system. And well, Japan had supported legal technical cooperation project since 1990s, primarily for development of the civil code or the civil laws in countries which were transitioning from socialistic system to market economies. It began with the request to Japan from a Vietnamese Minister of Justice for advice on revising their civil code, and subsequently the cooperation expanded to Cambodia, Laos, China, Nepal, Mongolia, and so on. We also work with other countries to improve judicial practice and the dispute resolution mechanism. In Cambodia, as a part of post-Civil War reconstruction support, Japan began drafting support of the civil code and the code of the civil procedure in 1999, while the criminal law was being developed with the support of France. And well, I also explained the special I also mentioned the special circumstances of Cambodia at the time. That is, during the Khmer Rouge era, the millions of the intellectuals were killed or they fled as refugees. In the 2000s, there were very few persons in Cambodia with the capacity to write law draft. The Khmer Rouge regime forced all the citizens to be relocated to rural areas to engage in agricultural activity equally, and abolished all laws and destroyed government documents such as land registries or others. So it is also said that when the Khmer Rouge regime ended in 1979, the only 4 legal professionals survived within the country. In addition, the education system was also destroyed by the Pol Pot regime, the people of Cambodia had no adequate opportunities for education for many years afterward. Amid these circumstances, Cambodia's Civil Code and the Code of Civil Procedure were drafted initially by Japanese law scholars. The draft in Japanese were translated into Cambodian language, and each article was reviewed and discussed by the team established in the Ministry of Justice of Cambodia and Japanese scholars. The draft of the Civil Code and the Code of Civil Procedure were submitted to the Council of Ministers in June 2003. Subsequently, the Civil Code of Civil Procedure passed the National Assembly in July 2006, and the Civil Code followed in December 2007. Both Cambodian side and the Japanese side worked very diligently in response to the Cambodia's aspiration to make robust law that could be used for 100 years. As a result, the two codes have a sophisticated yet complex provisions. During this process, around 2000, Japanese side got information that the Ministry of Commerce of Cambodia had plans to make a law on secure transactions. And in 2002, when the first draft of the ST law was completed, the donor consultant supporting the Ministry of Commerce and the Japanese resident advisor discussed the issues to coordinate their activities, but could not find a common ground. At that time, the donor of the Ministry of Commerce said that in introducing a system of securities on movable assets, there were strict standards, and their consultants and the Cambodian side had a little discretion. Also, enacting such a system of securities aligned with these standards was an essential condition for providing loan from the donor. The draft ST law was submitted to the Council of Ministers in 2004, and effort for coordination through the Minister of Justice, Minister of Commerce, as well as the Deputy Prime Minister continued until January 2007, just before the bill of ST law had passed the National Assembly. However, attempts to coordinate the Civil Code and the ST law were unfortunately not successful. In the traditional concept of the Civil Code, security interests are considered as a type of real rights, that is a strict right established over specific assets or items, and the existence of such right should be publicly shown by the registration in immovable property and the possession for the movable property. However, of course, there was a need to establish security interest without transferring possession of movable property, allowing the debtor to continue using the item. So the Cambodian Civil Code draft included a chapter on transfer as a security or transferable collateral. The draft ST law of Cambodia had a provision to allow the establishment of security interests over a broad range of assets and to publicly notice the security interest through a filing system. And well, I understand that this filing system is working very effectively there. The Japanese side expressed a particular concern that the broad coverage of assets, including collective property and accounts and others, conflicted with the rights recognized under the Civil Code. They also raised concerns that the power granted to secured party in debtors' defaults is too strong and questions its consistency with the Code of Procedure, which was approved in the National Assembly in 2006. Therefore, they proposed amendment of the draft, including provisions to protect persons who acquired collateral property in good faith and without fault, or to protect the original debtor when a claim became a subject of a security interest. And also the revision of the provisions transferring ownership to the security holder through the revision of the provisions transferring the ownership to the security holder through a simplified court order, which was absent in the already approved Civil Procedure Code. And also to limit the scope of application of the ST law to the commercial transactions. While the Ministry of Commerce seemed to have accepted some proposal in the stages of discussion, these proposals were ultimately not reflected in the law. The then Minister of Commerce was rushing to pass the bill of ST law, which was a condition for loans. And also he had a negative views on a civil law system, though the civil law system were the basis of the Cambodian legal system, not only by Japanese support, but also from the era of French colony. The Code of Procedure was enacted in July 2006. The law on secured transactions were approved in May 2007. And the Civil Code in December 2007, the same year, retaining its original provisions on pledge and transfer as a security. This meant the coexistence of two sets of laws with a different concept. Subsequently, the separate bill concerning the application of the Civil Code was drafted and enacted in 2011 by the support of Japanese team through the Ministry of Justice. This law stipulated the priority of security interest established by these two laws. So, well, I think there were three main factors behind the difficulties in achieving coordination in Cambodia. The first one is due to Cambodia's unique history, the human resource shortage continued for a long time, making it particularly difficult to coordinate draft bills between different ministries and agencies. Well, actually in Laos too, around 2018 or 19, the officials from the Ministry of Justice and the Japanese advisors were strongly urged by the donor consultants that if they do not introduce ST law, the ranking in the World Bank's doing business report will drop. However, the Lao official at that time replied that they would proceed with their legal reform at their own pace and in their own way, and did not accept the proposal.
Excuse
so
me.
another factor. Oh yes.
Did you come to a conclusion in about in a minute?
Yes. I'm
Thank
coming.
you very much. Thanks.
Yes. Thank you. So, well, another factor was the donors supporting the Ministry of Commerce imposed the strict standard and deadline as long conditions, leaving the little room for coordination with the local legal system. And the third one is the Japanese team also took too long time in some occasions for internal discussion to submit the information and opinions to the relevant institutes, such as Minister of Commerce or Council Ministers through Ministry of Justice. Some of those involved dogmatically adhered to the traditional theory of civil law. So while this resulted from a combination of various factors, I hope these examples in the history are kept in mind and for the constructive coordination in the future. Thank you.
Thank you for pointing us to the importance of coordination among the various entities engaged in legal reform, and also for the importance of looking at the legal framework already in the legal tradition already in the country. Moving on without further ado to the next expert, Mr. Charles Booth. Would actually probably we will hear more about Cambodia and Laos also in his remarks. The floor is yours. Thank you.
Well, thank you. It's good to be back to Hong Kong U. I taught here from 1989 to 2005. And when I arrived in 1989, Asia was booming. Everybody was making lots of money. Nobody was focusing on secure transactions reform. Nobody was focusing on bankruptcy reform, because when you're busy making money, you're not really worried about the infrastructure. And that's pretty much the way it was until 1997, when, of course, the major collapse occurred. And because the asset classes in Asia, real property, movable property, stock markets, so we're going up and down together, when the crash came, it came hard. The year after, in 1998, the Asian Development Bank actually put together the first law reform project focusing on these issues. Before then, the multilaterals didn't know how to assess these projects. Like if you build a bridge and if it falls down, you know it didn't do well. With insolvency law reform, secure transactions, they weren't quite sure what to do. So in 1998, they put together basically representatives from about 12 different jurisdictions. I was lucky enough to be the one from Hong Kong. And that's when discussions really started about starting to look at secure transactions reform in the region and insolvency reform in the region. Because back then, I still remember the question for the Indonesian representative was, how does a foreign creditor enforce interest in real property in Indonesia? And the response was, I don't know. I don't think it ever happened. Well, if it never happened, certainly the insolvency law wasn't going to work. So then at that time, as you'll remember, huge amount of law reform activity, a lot of it not really willingly by countries, but more in a position of responding to the multilaterals. You fast forward to today, totally different situation. The countries that Miha is talking about, they want a better secure transactions law. They want a better insolvency law. But my perspective is a little bit different since my main activity in the region has been on the insolvency side. And I must say, Miha, I enjoyed your presentation, but it seems I was sort of following you from country to country. I've been working on insolvency reform, judicial training in Laos. I've done judicial training in Cambodia. I've done insolvency projects in Mongolia and China. And you look at these projects, and I guess I'd like to come back to her first main point about the lack of coordination. And I think that is still the case. It's better than it was. But oftentimes I know on the insolvency projects, we get a copy of the civil code. We get a copy of the secure transactions law, but there's not a lot of discussion about it, and certainly no discussion whatsoever about it, whether or not it's been effective. And that's an issue that one should have. What I'd like to do is talk a little bit about what the insolvency law in Laos and Cambodia does to the pre-existing priorities. Because I know this room your orientation is mainly from the secure transaction side, and you get those that legislation infrastructure in place. But then oftentimes when the insolvency law reform comes later, they've got different priorities. And I think one factor in Asia that changes, especially in the countries we're discussing here, that changes the landscape is there's a great desire to protect workers. And if you're going to protect workers, the question is how to pay for them. And often a way to pay for them is to give secured creditors lower priority or even maybe go after their collateral. So I'll just go through a few examples from there. But what's interesting about in Cambodia is that the first thing that's striking is when you take a look at how the laws are drafted. And if you think about insolvency law is quintessentially different from secure transactions, and it's really the flip side of the coin. When you're talking about everything that Miha is setting up, you're trying to get this infrastructure in place so secure transactions can work. You want to make sure that the registry works, notice works, parties know what's going on. So when it comes to priority disputes, you can sort them out. But often when you're sorting out those priority disputes and you're thinking about them, it's more of a one-off. We have this asset, these are the competing claims, what are we going to do? And then of course, when you have a period like the Asian financial crisis or just a downturn, and you realize that if the debtor is not paying one creditor, likely not paying a lot of them, and you have a major insolvency problem, well, then it's very, very different. And that collective aspect of the insolvency law reform is very different. Now, one of the first and really challenging aspects of certainly Laos and Cambodia and also in China is that only a handful of these insolvent entities actually make their way into the insolvency system. In Cambodia and Laos, few if any cases. In Laos, a huge amount of time goes by. So does that mean there's no insolvency? No, there's a lot of it, but it happens in different ways. People walk away from the situation. Companies are dissolved. A huge problem in these jurisdictions, in the civil law jurisdictions, is that there's no personal bankruptcy law. It's almost impossible to deal with proprietorships and partnerships. And if the entity is not properly registered, then they don't want them to use the law. So actually, when you look at the engine of growth in the region in these countries, most people can't use the law because they're sort of locked outside of it. And even if they could use it, how are you going to pay for it? There's no money in a lot of these smaller cases. So what you need to do then in the insolvency law is you need to create actually incentives, in my view, for the secured creditor to stay in the game, because they're going to be the ones who are going to be funding things. Because you need money going forward to fund the corporate reorganization. And yet in so many countries in Asia, and I think both of these are examples, and in China too, to an extent, is that when the case starts, they look at the insolvency law as trying to resolve historic problems. And that has to do with workers. We want to pay the workers. But as you know, when bankers put new money in, they want to put money in to help things going forward. They don't just want to put money in to deal with dead weight looking backwards. And that creates a huge problem and major disincentives. Now, there's one easy solution to this, but that solution is a very expensive one. And that basically is you deal with workers' rights completely outside insolvency. Probably the country that does this the best is the US. And that's one reason why companies are very active firing workers. Right now, as we speak, they're probably firing thousands of workers at Microsoft and Google. Why? You get them off the books of the company. Uncle Sam picks up with unemployment insurance. And then if there ever is an insolvency, you're not dealing with so many workers. One of the problems in Asia is that the problem of the workers becomes a company problem. The company has to pay for them. The workers' priority is absolutely huge. And there's just no way that you can resolve that problem unless money comes in. And what you see here in both Laos and Cambodia is that the first problem is, and it's the very, very different than the detail you're talking about that you go into to get this secure transaction regime in place is very, very different from the insolvency laws. They're quite rudimentary. They're very simple. They don't go into the same detail that you have in other jurisdictions. And then on top of that, many of these countries actually enact their laws before the rules and regulations are in place. And you have a judiciary that's not familiar with it, and it's a recipe for moving slow. And what do? They move slow. They're afraid to accept cases. They're afraid to move through. So here, when we have secured creditors in both countries, they do things to entice the creditors to basically stay involved and stay in the game. And that is, they will pay them post-petition interest, which of course unsecured creditors won't get. Both countries, and this is Laos and Cambodia, have really no real discussion of offering adequate protection to creditors to get them to stay involved. So what that generally means then is that even though there's an automatic moratorium that applies to the secured creditors, there's actually incentives for them to try to get out of this case, to try to get their collateral back and just deal with it themselves. And that's one of the problems, that basically the incentives for, rather than staying in, and since there's not going to be adequate protection, it might be better for them just to try to get their assets and take them out. Also, you take a look at the priorities that these countries have. In both of them, employees come first before secured creditors. In Laos, it actually tracks what is happening outside bankruptcy. It's kind of interesting. I enjoyed your discussion of the interaction between the civil code and the secure transactions law. In Laos, when it came in, they gave a priority to security interests at law, but it's very difficult from the legislation to get a sense of how that would work in practice. There's actually, I found one case from 2013 that says that workers' wages will get paid before the secured creditor, but that priority does not apply to longer-term benefits. What's kind of interesting is that even though I've spent several months in Laos working on this, it would have been helpful if someone had given me that case, but we didn't have that case. We just dealt with what the legislation was and was trying to work through how that might work. So employees' wages come first. Secondly, you have your administrators' expenses and the administrators' fees. And one of the benefits of these new insolvency regimes that are being enacted is the heart of it is this insolvency professional. And a lot of what we're trying to do is train the professionals because they can handle these matters in a way that the judges can't. So what you see here now, however, is that these are purely insolvency expenses, and they too are going before the secured creditors. So the secured creditor had the asset there, and now you've got two groups ahead of them there. And then on top of that, they'll throw in the other administrative fees as well, and might as well throw in some court fees as well, as long as we've got we're going to have the priority scale. So if you're a secured creditor looking at that, this actually is not a process that you want to be involved in, and that maybe is one reason. If you look through there's why there's so few cases with that. So they sort of have that a little bit backwards. Now, what's interesting about Laos is I did mention that because of this case, even outside bankruptcy, the workers will have priority over the secured creditor. The case, as I said, did note that it was only for wages, and yet nevertheless in the insolvency law, basically you also have a priority for unpaid contributions on Social Security payments. So again, here too, even though they keep the workers' priority, they actually go beyond it and push it a little bit more. So with those aspects of it, you've got some major problems. Just want to make a few comments just about China and Hong Kong to finish up here, because there's other ways of dealing with this issue. And what China has often done is because they have a very pragmatic approach, they just try a lot of different things. And one of the things they've done in the past is that if you take a look at the actual insolvency law provisions, you'll have a traditional priority, just the priorities in the law where secured creditors will be able to get their collateral, but then they'll issue some policy decrees. And for a while, what they were doing is, in China, you can't own property, but you have the ability to basically access payments for the use of the land. And then what they would do is they would use money coming from that for the resettlement of workers. They didn't want to fire the workers, but they would resettle the workers. And then those workers, the expenses for the workers would then leapfrog over the secured creditors. And back when they were negotiating the 2006 law, the treatment of what to do with this dispute of the workers vis-a-vis the secured creditors was a very big one. And as China often does, they came up with an interesting compromise where the law reads in the traditional way, but for older SOEs that predated the enactment of the law, rather than just dissolving those entities, which they really couldn't do, because for the SOEs, even if they weren't operating in a corporate capacity, you still had people living on the premises, medical benefits being given, they were still there. What they did was they grandfathered those claims. And if any foreign investor ever wants to come in and move in that direction, they're going to have to take care of that. And then what we'll end up with here is that what China's also done recently with the real estate crisis, the same way they leapfrog new levels of priority. So basically homeowners have to get their flats, contractors have to be paid. So I mentioned this just because with all the discussion of what you're doing increasingly with this conference of digital assets and the like, you need to take a look at what countries you're in and what they might be doing and what priorities they might put above your assets in terms of the scheme, and then take a look at what they're doing with the workers. And I'll leave it at that.
Thank you very much, Charles. That was very interesting to look into these aspects that are also very important for secure transactions. Moving on, I'm giving the floor to Angelia, and your 12 minutes of driving us.
Thank you, Monica. Thank you for the organizers for organizing this event. I'm finding it particularly intriguing. I do come from a very different background. I was actually practicing just about 3.5 months ago. I was a partner in a law firm before I joined Asian Development Bank. So I'm actually joining from the perspective of being the user of the legislation which you had spent years putting in place. And it's quite interesting for me to come in from a user standpoint and look at all the challenges and issues that I see when I was putting multi-jurisdictional secured lending financing transactions in place. My style of presentation is interactive, so if you've got any questions along the way, please do let me know, and I will try to address them as I see fit. So coming from my perspective as the user of legislation, and I do hear about Monica talking about possible amendments that we can think about. And just sort of take a step back, the focus of all of this legislation is to really help the small and medium-sized enterprises, the micro, small, medium-sized enterprises to actually have access to finance, particularly trade finance, so that we can actually lift economies out of poverty. One of the key issues that supply chain finance makes it really, really good for small and medium-sized enterprises is that you are allowed to substitute the credit risk of the small, medium-sized enterprise with the big anchor buyer who's making payments, right? And that substitution of credit risks allows small, medium-sized enterprises to actually have access to finance. So there is a strong focus on one aspect of supply chain finance, which then breaks down into two separate aspects, your loans or your receivables purchase aspects. In respect of loans, the model law of secure transactions is really, really critical because of all the certainties it creates and puts in a really, really good framework with respect to a lot of movable assets that can actually constitute collateral, which most small and medium-sized enterprises don't have. The specific area that I want to focus on and the challenge that the UNCITRAL model law and secure transactions actually posed from a practice standpoint was particularly in respect of the outright transfer aspects, where under the model law, outright transfers of receivables actually constitutes a security. Whenever we structured secure finance transactions, we always have to balance the on balance sheet, off balance sheet positions of the lenders, the obligors, the borrowers. And if you classify an outright transfer as a security, then the borrower could sometimes breach the negative pledges, the negative obligations in a loan agreement, because that loan agreement would say you're not allowed to create a security. And so the inability to actually sell their receivables on a without recourse basis and not let that be a security arrangement impeded their ability to gain even more financing. So that's one key issue why there's been a lot of resistance, at least from the common law standpoint, and those who use the Loan Markets Association's LMA template agreements to say, no, that's going to be a huge spanner in the works for us. The other aspect in terms of receivables purchase, one of the reasons why reverse factoring payables financing has been so effective is that it took away a lot of the issues with outright transfers of receivables. By having a contract between the financial institution and the buyer, that contractual arrangement allowed the lawyers to reduce the uncertainty. We take away a lot of the conflicts of laws issues, the private international law issues, by saying, look, buyer, you are going to pay me in all circumstances, without dispute, without set-off, without counterclaim. And that contractual arrangement between the financial institution and the buyer then reduced all the uncertainty that the financial institution would normally have. And that also meant that we could take away all the local law issues and uncertainties and court issues that arose. However, the problem with payables finance from a developmental standpoint is that it's so concentrated on the large global banks who have the relationship with the buyers. And now the buyers are wielding so much power over the small and medium-sized enterprises that we are having this imbalance again. And the imbalance is not just in respect of the companies, but also of the financial institutions, right? Because the global financial institutions are just completely taking over so much control. And where do the regional banks and the domestic banks come into the play? That's where I think Asian Development Bank is trying to take a slightly different approach and say, look, how do we balance the playing field a little bit? How do we reduce the knowledge gap? And to Murat's point, it is a multi-pronged approach. You have to approach not just the regulator, the financial institutions, but down into the operational credit risk, legal teams within the financial institutions and the industry to go, this is how you should look at it. This is how you should understand the issues and how we really explain down to the nits and grits, down to compliance with the Basel Accords, operational risk, and all of those issues. Because a lot of trade finance is not just in your four corners of your agreement. There are policies and procedures in place that we do have to take into account to ensure that your trade finance product works. And I speak, as an in-house counsel, head of legal for Standard Chartered Bank. And so that's a slightly different dimension to it. So whilst payables finance reverse factoring has been extremely effective, I think we should also focus a little bit on receivables purchase and that aspect of the assignment of receivables. And here, if we can relook at how the model law on secured transactions focuses on outright transfers and maybe provide some clarification and tweaks so that the legislation works well in practice across multi-jurisdictions, so we have greater harmony, and that may actually help balance the positions a little bit. And with that, I will hand it back to Monica.
I'm actually surprised. I was looking at you because I was fully into your presentation, not because I wanted you to stop. You still have a few more minutes to go with you, but I thank you because you, first of all, you have actually drawn our attention to the challenges of MSMEs. And I come from in UNCITRAL, actually, that has been my focus for a number of years. So I was already, that's why I was, and also for drawing our attention to the issues of receivables that are dealt with in the model law, but many times when we speak about the model law, we actually focused on, part of secure transactions and receivables, yes, are there. But so I thank you very much. And without further ado, passing the floor to Cesar, Julius Cesar. That's a very important name for an Italian, and there's a lot of history in a name such Julius Caesar for us. And with your presentation on the reforms in the region. Thank you.
Thank you very much. And I think that's why I always feel there are several knives on my back. So first of all, thank you. And thanks to Jay, Monica, and Giuliano for inviting me here, which I hope will be my last business trip for this year. I will be in Rome later next month to attend the UNIDROIT working group meeting, but that will be part of my vacation. So this presentation is an overview of efforts within APEC to promote secure transactions reform. And just to explain why I'm talking about APEC is, so I have a day job, which is to work in a bank, which is the Sumitomo Mitsui Banking Corporation in Japan. But APEC is my day and night job. So I've been doing APEC for a long time, even at night. Okay. There you go. So this is not a new issue for APEC. And this harks back to the Asian financial crisis, as Charles mentioned earlier. In 2002, the Group on Strengthening Economic and Legal Infrastructure under the Economic Committee served as focal point for discussions in APEC. In 2013, the APEC Business Advisory Council, or ABAC, proposed the elements of a model code. And that same year also saw the establishment of the Asia-Pacific Financial Forum, or APFF, a platform for public-private collaboration among experts from industry, multilateral institutions, and government agencies to assist member economies in undertaking secure transactions reforms. And some of you, I'm sure, have participated in some of the works that we've done. In 2015, the APEC finance ministers launched a 10-year roadmap, the Cebu Action Plan, which named secure transactions reform as a priority issue. The work of ABAC and APFF through the years has been guided by the elements of a model code of security interest creation, perfection, and enforcement, which was developed by the APFF, specifically the APFF network on secure transactions reform, which at that time was led by Tom Clark, who's now the general counsel of ADB. At the time, he was working for GE Capital. And these included elements such as the scope of asset types, process for enforcement, perfection of security interests, transparency, creation and perfection of lien on receivables in relation to non-assignment clause, how to deal with conflicts arising between provisions in insolvency and security laws, and how to deal with obstruction of enforcement of security interests. For many years, ABAC and APEC have promoted secure transactions reforms in the region in partnership with the APEC Economic Committee, the finance ministers' process, and various public and international institutions. Work with justice and finance ministries, central banks, and legislatures has helped some member economies in introducing legal reforms, including in Brunei, Darussalam, and the Philippines, which passed new secured transactions laws, and in Vietnam and China, with the secured transactions chapters of the new civil codes. And these legal reforms have been followed up with supporting regulations and institutional structures and continued legal reform efforts in other jurisdictions like Malaysia and the Philippines. In spite of these achievements, as the previous speakers have explained, much remains to be done. And this is in terms of legislative reforms in several more jurisdictions. Also in terms of developing the implementing regulations, supporting policies, institutional and market ecosystems, including collateral registries and supporting industries. And also in educating lenders, borrowers, legal professionals, and judges on how to maximize the benefits under the new secured transactions frameworks. And this will be critical for scaling up the market for movable asset-based finance. The successive efforts to promote secured transactions reform necessitates cooperation across a number of relevant ministries, regulatory bodies, and the legislature in any one jurisdiction, as well as the support of stakeholders from business and industry. Legal and market expertise and the sharing of experiences from other parts of the world have also been critical in the design of legislation and regulations and in the development and scaling up of the market. In this regard, the APFF has provided a valuable platform for mobilizing experts from a wide range of public and private institutions and international organizations to support the reform process. Over the past 10 years, various roundtables, conferences, symposia, workshops, and dialogues have been held across the region to respond to jurisdictions' requests for technical advice, to consolidate support from relevant stakeholders, and to promote awareness of secured transactions reform and its benefits. Before I conclude, let me speak a bit on our latest project, which is a proposed reform strategy on intellectual property finance. IP, as we all know, is the most valuable asset of many small businesses. If enabled, unlocking its full value can help close the financing gap for many of these businesses. However, enabling IP financing will require overcoming a negative feedback loop around the limited use of such products, incentives for the policymakers to act, and incentives for the market to develop these products. And so to address these issues, ABAC, with the help of our APFF IP Finance Working Group, which was led by Giuliano over here and Johnson, so also here, proposed a product-focused reform strategy that centers on piloting IP-based products through testing in a sandbox, followed by reforms to correct the immediate impediments for the selected products, and then to ensure credit products are aligned with international standards. The proposed roadmap consists of three main phases. The first is the diagnostic phase, where we propose to select participating jurisdictions and the specific IP-based lending products to be tested. The second is the sandbox and pilot phase, where specific lenders and borrowers are selected as participants to test the chosen IP-based lending products. And the third is the reform phase, where based on the pilot's results, specific reforms are implemented as needed to address the identified impediments. And hopefully, through this strategy, we can promote the successful deployment of IP-based lending, the improvement of laws in secondary markets, and ultimately the expansion of the IP-based lending market. This initiative is currently being progressed with the APEC Intellectual Property Rights Experts Group, or IPEG, and the Economic Committee, or EC. Following the joint virtual workshop with IPEG last May, we co-organized a hybrid workshop in Incheon last August, where the IP offices of Korea, Chile, Japan, and Singapore, WIPO, UNCITRAL, UNIDROIT, and legal experts from academia and industry expressed their support for advancing IP finance. At their subsequent plenary meetings, IPEG and the EC endorsed steps to advance the initiative. IPEG referenced the two workshops, echoing in its report to the APEC Committee on Trade and Investment the conclusion that APEC can play an important role in mobilizing private sector financing to scale up the IP finance market. The Economic Committee endorsed the proposal to develop an APEC project concept note on the use of IP, among other movable assets, as collateral, with Hong Kong, Japan, Peru, Philippines, and Thailand expressing their interest to co-sponsor the project. In addition, Hong Kong and Singapore have started discussions on sandboxes to implement the proposal, and tomorrow afternoon we'll have a meeting with Hong Kong relevant policymakers, including the IP office, to discuss the way forward. So in summary, there's been a lot of work in APEC to promote secure transactions reform. There are significant achievements, but much remains to be done. Multi-stakeholder platforms like the APFF can contribute to success by mobilizing expertise across the region and across institutions to support the ongoing work and bring secure transactions reform to new frontiers, like the wider use of intangible assets to access finance. So that concludes my presentation. Thank you very much. Back to you, Monica.
Thank you, Cesar. Really interesting, in particular, to see what is done at regional level. So the involvement in the activity of regional organizations, and also for opening this the window on IP finance. So that's another potential for increasing access to credit, for also for small and medium enterprises. I wouldn't say micro, but creative startup, yes. Last but not least, we are moving fast in the third millennium. So we are jumping from Hong Kong to Africa. And it's my pleasure also to listen to the last presentation of this panel, presenting on the experience of Uganda with secure transaction reforms. Thank you, Stellah. Floor is yours.
Thank you, Monica. Good morning. My name is Stellah from Africa and Uganda in particular. I'm happy to be here. And the fact that the first presenter talked about the challenges that we still have, I'm comfortable because I thought I was the only one who had challenges in this area. I'm a banker by profession. I have worked in the banking institution for 10 years. I joined the collateral registry. I work in the collateral registry. Basically, my work is to man the collateral registry. The reform in Uganda started way back. We had a manual register and the Chattels Transfer Act in 1978. That was the act was operating in 2025 at that juncture. So before 2014. So this act, of course, it was so manual, we couldn't do much. So in 2014, we got a new act, that is the Chattel Securities Act. However, it couldn't support the electronic collateral. So it had to be a physical filing of the collateral. Then the government of Uganda, of course, with the challenge of access to credit for MSMEs. This is where the whole problem is. In our country, we still have a very big challenge that small businesses cannot access funds unless you have the traditional collateral, which is land. And of course, land is not something that everyone can access, especially small businesses. So the government embarked on the journey to reform the collateral registry to make sure that small businesses can access credit. In 2019, that's when we got a new law. After doing a lot of benchmarking in African countries, and of course, the World Bank came in to help us. And that's when we got IFC, we got experts. And these experts introduced us to UNCITRAL model law, the guide, secure transaction, the registry guide, and the model law. And these were adopted in our new act. A lot was done in the act, although it was very new in our country. So to us, it brought in something new that we have been working on. It brought an online register, something that really shifted the whole experience because it was manual and a bit complicated to have. So this new reform, but sorry about that. This new reform gave us an opportunity to really look at the option of promoting movable assets in Uganda. This was not welcomed by many institutions, especially commercial banks, because they believe that movable assets have low value, and the fact that our country still has challenges of legal traceability, delays in court, we have case backlog. So you find commercial banks are struggling with immovable assets. Court cases take years to be heard. So they are looking at movable assets that lose value very often and in a short time. So if it is going to spend 2 years in court, 3 years, it's not going to help them. So they boycotted the whole thing. And to bring the point home is the central bank was also not supporting because it moved with the banks. Of course, we still have non-performing ratios that are high. So they also believed having this small, having movable asset will increase the problem. Nevertheless, we implemented this and we have been promoting it. But along the way, because the fact that we have been engaging with commercial banks and other lenders in the country, we got to know their challenges. One is when this law came in place, there are other laws that were competing, fragmented. There are other instruments that were created. Every time there was a problem, they created an instrument that conflicted with this law. So you find that we have dual registration. You find that you have to register with us. You have again to register with the company's register. Surprisingly, Uganda Registration Services Bureau has the company's register, has insolvency, has the intellectual property, but we are still conflicting and has security. So you find that this is a challenge and we intend to narrow it down. Of course, the central bank didn't participate so much. We are still trying to work with them. Enforcement procedure. In this act, we have court dependence, basically. You either go to court or nothing else. So something that it's still impeding because enforcement is very key in our country. Then it has to be public auction, no private. And even when it is public auction, it doesn't have enabling factors like, for example, online markets or any other thing. So you find that it is a bit complicated right now. Again, these assets that we are promoting are not serialized. They cannot be identified out of this juncture. We only have asset-specific register that is so common is the motor vehicle that is so unique. But the remaining ones do not have traceability. You can't trace them. So you find it is very complicated for financial institutions to take them up. Then, of course, like I told, we have intellectual property. We register intellectual property, but these assets are not known in our country. And the fact that these lenders, especially the commercial banks, cannot have specified or licensed valuers to determine the value. Later on, have the market where to sell these assets in the event the client completely defaults. So you find that the industry is not developed. The law is up to, the standard is so good, but the industry is still low. So that is the challenge we have. It's not yet developed, and catching up with these standards is quite complicated. There are emerging assets that we see, that we hear, that we learn of, but our country is still not the legal fraternity, you can imagine where I come from. Our register is under the Ministry of Justice and Constitutional Affairs, but amending a law still takes forever. But however, we believe that having us under the Constitution, it has helped us to push this further, and we intend to do a legal review so that we can be able to promote it further. What have we, no. When I was talking to Monica on email, and she talked about carbon credit and digital assets in Africa, especially Uganda. This is something that is new and evolving. And when I was reading through it, I was excited to see that there's a law coming up, something that is good for us in our country. I never expected it to be this fast, but I feel much as it is coming up, it will be able to be put across. Although, like I said, we still have challenges of valuation. We'll have the law in place, enforceability will not be possible because we still have quite a number of challenges. Until we address those challenges, yes, the law is good, but implementation is still a challenge. So those digital assets, carbon credit, is something new. We are welcoming it, but however, we need to work on the challenges. As a government entity, we are doing our best to make sure that asset-based lending in Uganda is promoted. so that we can be able to extend credit, because this is our biggest challenge. To us, the registry, this is a benefit, because you see, if everybody is looking for credit and we're here to promote credit, we get a bit of attention. So since we rolled out the registry, we used to have around 300 registration in a year manually, but currently we are looking at 20,000 in a year since we joined. So what has really promoted the registry is when we looked at asset-specific registries. So we do interoperability, in that once we connect this register, we lock the manual and outside world. So everybody has to go through our register to access these specific asset-specific registers. So this one has moved the registry so high. Unfortunately, the warehouse receipt register that we have, the law is still, should I say obsolete? We yet to reform it, and it is very hard for us now to connect to the register. And then we have receivables in Uganda, and only the commercial banks that are supporting receivables. However, you must be their client who has stayed with them for quite some time and who has more assets, that is immovable assets already. So you find that loans are over collateralized. There is immovable, then they take the receivables. So you must have that, you must have created that trust for you to access receivables and be funded accordingly. So you find that it is still on a limited scale, accessed by very few people. So you find that, yes, the law is in place, but even our law is not that detailed. It is just mentioning receivables. So these are the things that we intend to do to reform our law and capture these new assets so that the law can support. Because our country is still developing, it has challenges, and then you find that if the law is not supporting that well, it is very hard for, especially commercial banks, to take these products. We have done a number of efforts. We have really moved hard. When we are doing this registry and we encountered challenges that my colleague talked about from the beginning, we decided to benchmark with African countries, but we realized that most of the African countries, the register is in central bank, but it still has specific problems that we have. So when we kept on referring them to international registries and all that, the excuse was these are developed countries. They already have everything in space. But again, we realized that we need to develop ours. So what we are doing as URSP is we want to have an African collateral registry forum, because most of African countries are facing the same challenges and we believe can be sorted. Others have even the law, but they have failed to establish a register. So we find that that is something URSP is pushing. Currently, we are at cabinet level, and soon we are going to have this forum in place. We invited the World Bank through Ministry of Finance, IFC, to have a project that will enable us have enforcement on this level. And now, when we invited IFC, it has come, the project has commenced, and this project is going to look at legal review. It's going to look at the ecosystem. It's going to look at the valuation and disposal mechanism and promoting knowledge. Recently, we went to Ministry of Justice and Constitutional Affairs, and in particular the Judiciary Training Institute, and requested to speak to them about the law, the new law. And they were so excited about it, and they are willing to give us an audience. So we believe if we engage the judiciary and all others, that we'll be able. Uganda is reforming our act. Dr. Marek did our regulations, and we have requested IFC to bring him back so that he can do the act, so that we can have the standard act again with the reforms and the regulation. I hope he will accept our request. I thank you. That's all I can offer.
Thank you very much, Stellah, for guiding us through the successes of the reform in Uganda, but also for the work that is still to be done and the commitment also from the part of Uganda to do such work. We are slightly behind schedule, 5 minutes. I know that we need to be, quite on time because then we also have to take some walk to the restaurant. But can I, Giuliano, can I get 2 minutes for questions or comments from the audience? But Richard has.
Just had a comment in dealing with the question of priority accorded to wage claims. And in practice, what we see, it's very interesting. Those preferential claims tend to be counterproductive because lenders will often simply reserve back part of the loan proceeds so that in the event the wage claim becomes payable, they'll have the money to pay it. So the borrower gets less money. And the other thing that I see happening is in a country like Mexico right now, the wage lien claim is an insolvency claim, as I'm sure you know. And so lenders are looking for ways to avoid the possibility of insolvency. So they're using a security device known as the guarantee trust, the fideicomiso, which is bankruptcy remote. And that's a way to sidestep the wage lien claims. So that's what's happening in practice. They tend to be counterproductive.
No, I agree with you. The irony is that the way to increase distribution to workers is to lower their claim, and they'll probably get paid and not scare people off. One point I want to make, I didn't have time in the presentation, is this dispute over wages is the reason why Hong Kong does not have a corporate rescue law. Because the proposal that has never made it through is that for a company to file for what was going to be called provisional supervision, the initial proposal was to pay off all workers' claims in full before you file. That, of course, did not go over well. So then they said, okay, then pay off as much as you would get under the Protection of Wage on Insolvency Fund, which was still well over up to over 35,000 US a person. That did not go over well. They kept on coming back, and at the end of the day, it just wasn't going to work because that was unsecured. And that meant money was going in and it was just going to disappear into these old claims. And you haven't even started funding going forward yet. So these incentives for keeping the secured creditors in the game are actually key to making it work. And when we've seen in real estate cases, you want to be able to stay in the game. So there's still assets that you'll have on your balance sheet when you come out. So you need funds coming in, and it makes it very hard to do that.
Thank you. Yes, Ignacio?
First of all, they have the priorities of employees in the Constitution, in the Zapata Constitution. So the World Bank always found huge problems in trying to tell them that was undermining its insolvency system because it's part of the Constitution. So there's very little you can do. Actually, it gets even worse because any employee has a right to huelga, which means basically they have a right to enforce individually, even at the expense of other employees. So it's a wild world. That's one of the reasons why they go to the United States to litigate their insolvencies. That's another one of those reasons. And the fiducia, or this fiduciary right of assignment that you described, which is done everywhere in Latin America, also in Peru, for example, and many other countries, has also its problems in terms of sometimes and often is unregistered, and therefore it provides a de facto monopoly to financial institutions at the expense of non-adjusting creditors and other creditors that actually could adjust by creating. So there's also plenty of space to improve in that area. Actually, I wanted to link this very a little bit of the topic point with a question to basically everyone in the panel, which is, I remember from the old days in this region and some of the countries which were mentioned, Laos and Southeast Asian countries, but also in Africa. One of the main problems was that there was no need, or the market preferred not to use secure transactions because it was more efficient to structure the transaction in a check. And if you didn't pay the check, you go to jail. Is that still being used? So it's like a substitution of secure transactions regime by some sort of alternative, money lending, which obviously undermines credit substantially. It's not the way to go. It's still happening. I just wonder.
From a practice standpoint, I think, which is one of the reasons why MOLITA, the model law on electronic transferable records, is very interesting. The use of negotiable instruments, checks included, bills of exchange, promissory notes, does take away a lot of the issues, primarily because where this type of instrument is legislated, it creates an independent payment obligation. And usually any dispute in respect of the underlying transaction is irrelevant because the courts will allow you to summarily, through a faster court procedure, enforce that independent payment obligation evidenced by the negotiable instrument. And it also takes away a lot of the uncertainty in relation to security and things like that. On top of everything else, I think one of the challenges that we find in practice about registries is that movable assets turn around very quickly. And to constantly update and amend at the registry is actually an administratively cumbersome process. In one of the lending transactions that I did, secured finance transactions that I did with regards to China, there were so many receivables, and there was a limitation as to the number of receivables that could be actually updated electronically. And so the bank had to, it was a very laborious administrative process to constantly update the registry, even though there was one registry. The challenges we also find about registries is you're not really certain as to how effective the registration process is in certain jurisdictions. And there's usually a time lag, right? Even the fastest registries, they'll say, look, it'll take me about a day or two to make sure that everything is updated. And sometimes the transactions and the speed of financing within commercial banks is so fast that that time lag does make a difference. So there are quite a number of practical challenges with respect to registries. The other aspect is, how quickly you take to check the registry, and that whole thing slows down the whole financing process when you've got very, very short turnarounds.
Just very quickly also to add, Ignacio, this is unfortunately still a practice in many markets in the Middle East in particular. It's very easy for banks, obviously, to rely on the post-dated checks, which is both the payment instrument on the one hand and at the same time also kind of a security. But it's not really a good practice. It's a very archaic system because it has all this sort of criminalization aspect written into it, which has nothing to do with the modern secured finance. And in Jordan, for example, the reason why banks are now suddenly rushing into supply chain finance is because the Central Bank of Jordan recently removed the use of the post-dated checks as a kind of this quasi pseudo security device. So now banks now have to find something else what to do with because now they can no longer use this as a threatening sort of tool to enforce the payments and then compliance from the borrowers. So we see that some markets still utilize this post-dated check device as a device, but it's fading away, luckily. Yeah, and modern secure transactions hopefully will step in to substitute that.
Thank you. Thank you for your replies, Angelia and Murat. And thank you to your questions. I would suggest, otherwise I don't want that our host gets a little bit concerned. Maybe additional questions at lunchtime, maybe on an individual basis. I would like to thank all the speakers, all the panelists. I'm going away with a few catchy words, like that I was noting down, champions of reforms that trigger success as much as possible in practice, coordinations, Importance of note is the local and the background framework and the institutional framework, cooperation at international level, importance of using, being vocal and using conferences, workshops, dialogue, new avenues for access to credit, like IP-based finance, journey to reform. Is once you have a new law, is never the end of the journey, the reaching point, but it's maybe the beginning of a journey. And never forget that there are also other laws that needs to be taken into consideration, not just the area, the law regulating the area you want to reform. With that, I wish you, well, buon appetit, actually buon appetito, as we used to say in Italian, and I'll pass the floor to the host, to Giuliano.
Welcome back, everybody. Hope you had a good lunch and you are refreshed to start again. So this morning, we discussed different trends in terms of current and future works in international standards. We heard from UNCITRAL, we heard from UNIDROIT, we heard from HCCH, sorry. Then we heard also how the implementation of these different standards when we're doing law reforms to stimulate access to credit occur. So we saw different focus on type of products, type of assets, and actually we also noted that different changes are needed to make access to credit and sustainable finance real. Now, in this panel now, we are going actually to focus on the core theme of the aspect of coordination. And the idea is that we are going to look exactly at the machinery of ensuring coordination within different legal and regulatory framework in the context of intangible assets, be them digital assets broadly defined, such as tokenization, or being also intellectual property. So to do that, we have nonetheless then a fantastic panel of 5 incredible leaders that represent the core function of the system that will actually enable the possibility to unlock credit. So we will start, I'll give you a sense of the narrative, and then my job, it will be essentially to talk the least as possible in order to leave the room to this fantastic guest. So we will start with Ms. Carmen Chu, Executive Director of the Hong Kong Monetary Authority. She will provide to us with a broader banking supervision perspective and the approach that has been effectively enacted, and then with an example of what Hong Kong and the MA, the Hong Kong Monetary Authority in particular, have been doing in this year. We will then have Mr. David Wong, Director of Intellectual Property Department of the Hong Kong government, who will actually give us an example, a practical example of what has been doing in Hong Kong to support IP finance and then the policy design that are actually necessary to that. We will have then pass the floor to Ms. Hazel Low, Associate Director at the Securities and Future Commission, and she will address the frontier of virtual asset custody investor protection in order to complete this cycle. Then we will have the pleasure to have with us Mr. Rocky Tung, that is Director and Head of Policy Research. I think that we can say also executive soon, so, of the Financial Service Development Council, a leading think tank in Hong Kong set up by the government of Hong Kong in order to guide policy change and inform policy change. But we will hear more from Rocky. And this will give us a broader perspective, right? He will open up the view, which will be finally complemented with a comparative perspective by connecting remotely, if we manage, okay, good, with Mr. Tomio Mitsutani, that is Director at the Financial Service Authority of Japan. So without further delay, I leave the floor to, and I invite Ms. Chu to actually begin.
Testing. Good afternoon, everyone. A very warm welcome to those who flew into Hong Kong for this event. It's really great honor for me as an alumni to come back here to the Hong Kong U campus, and also as a banking supervisor today to share the insights on promoting the assets to credit for particularly small and medium-sized enterprises in the new digital era. This is not just about supporting individual businesses. It is about fueling the economy, because SMEs actually represent 98% of all the corporates and contribute 44% to the total employment in Hong Kong. And similar importance is attached to the SME segment in other economies as well. So think about how technology and innovation have profoundly changed our daily lives, as well as the way businesses operate. Today's SMEs don't just use technology, they actually harness technology to help them to raise competitiveness. From e-commerce platform and real-time digital payment to cross-border business connectivity. So the shift has fundamentally changed and transformed the business operations, and also redefined the credit demand. SMEs now requires credit for a much wider range of different purposes, including investing in technology, innovation, also transformation and upgrade. And according to a recent study by the WIPO, corporate R&D spending reached a record $1.3 trillion last year, reflecting a significant funding need for technology and innovation development. And credit demand evolves alongside business models, meaning that the traditional credit models that focus on physical collateral and short-term liquidity may no longer be sufficient. So therefore, the credit supply should also evolve. And banks as financial intermediaries need to rethink their approach in terms of both products and services, as well as their mindset. We need to understand the client's business prospects and anticipate customer needs. The funding that SMEs need today is not just for survival or maintaining business as usual. The credit needs have evolved in tandem with the ambitions to transform. We are seeing changes in SMEs' credit demand in response to three transformation trends. First, SMEs leverage technology and digitization to streamline their business operations and improve their operational efficiency. They are also making greater use of data to meet customer needs and adapt to market changes. Second, going green is a business imperative that helps SMEs reduce costs, gain access to the global supply chain, and attract investors, thereby enhancing their competitiveness. And third, SMEs in Hong Kong are increasingly looking into new markets in ASEAN, in Europe, and beyond, so as to diversify in times of economic and global uncertainty. So one can't expect SMEs to grow and transform without adequate financial resources to support them. So the question is, can the traditional model of short-term, collateral-heavy credit fully support the evolving needs of SMEs for their long-term transformation. For decades, credit has relied on bricks and mortar physical collaterals such as real estate, inventory, equipment, etc. But in today's knowledge and digital economy, the most valuable assets are invisible or intangible. According to the WIPO, the global value of intangible assets reached an all-time high of around 80 trillion US dollars last year. Intangibles made up about 90% of the value of companies in the S&P 500. For many innovative SMEs and tech startups, intellectual property, including patents, trademarks, and copyrights, is often the only real assets. Despite this, many banks around the globe are still relying on tangible collateral for lending. Difficulty in valuation of the IP assets, absence of a transparent secondary trading market, and the lack of solid understanding of IP by many lenders and investors, all of these pose challenges for IP financing and the associated risk management. So we therefore need innovation in financing to unlock the potential of intangible assets like IP and turn it into credit facilities to support sustainable growth. As a supervisor, the HKMA put a lot of emphasis on promoting the stability of our banking system. But we are also mindful that banks have a critical role in financial intermediation, which channels funds to support real economic activities. And here's where our balanced supervisory approach comes in. One of our priorities is to promote credit flow without compromising credit risk. By this, we mean to encourage banks to support real economic activities under the overarching principle of prudent risk management. First, we need to listen carefully to the needs of SMEs in terms of their financing needs in order to provide targeted and suitable financing support for them. So that's why last August, the HKMA, in collaboration with the Hong Kong Association of Banks, set up a task force on SME lending. And through regular engagement sections, we have heard directly from SMEs that they need capital for their business upgrade and transformation. In response, the participating banks in the task force have set aside dedicated funds of 420 billion Hong Kong dollar. And this can make the SME financing more accessible and more targeted, tailored, among other support measures. At the same time, as the regulator, we also try to enhance the data infrastructure. For instance, our commercial data interchange, what we call the CDI, since its launch 3 years ago, has facilitated over 71,000 loan applications with almost 60 billion Hong Kong dollars in credit approval. And this has enabled banks access to alternative data, such as e-commerce sales records, import-export declarations, as well as government data on top of the traditional, conventional type of financial statements. Meanwhile, the other initiative, what we call the cross-border data validation platform, which is blockchain-powered. It was launched in last May, and it enables secure real-time verification of documents for cross-border lending. And it supports over 150 million Hong Kong dollars in cross-border loans so far. With better data, banks will be able to assess risk more accurately and in turn can facilitate more, quicker, and even cheaper credit to SMEs. Another priority is responsible innovation. This is to support banks in adopting new technologies and developing innovative financing while maintaining dynamic yet robust guardrails. We have started promoting responsible innovation using a sandbox approach. It began like a decade ago with the launch of the FinTech Supervisory Sandbox. And since then, over 380 FinTech trials have been tested, and many of them have now been productionized. In the past 2 years, we have also launched the Gen AI Sandbox and the Supervisory Incubator for DLT to promote responsible AI adoption and support the safe and prudent rollout of DLT services. The first cohort of the Gen AI Sandbox have 15 use cases, and that was concluded last month. And it actually confirmed that AI has the potential in banks' operation areas like risk management, anti-fraud, and customer engagement. And building on this momentum, the second cohort was just launched, attracting over 60 applications. And now we have 27 use cases in the second cohort, which will be trialed. And additionally, there are 7 banks which have been admitted to the DLT incubator to explore tokenized deposits and digital asset custody services. Building on all these sandboxes and incubator, and we note that there is a growing interest in exploring the use of IP as collateral for bank financing. So the HKMA, in collaboration with the Commercial and Economic Development Bureau, as well as the Intellectual Property Department of the government, we will be launching an IP financing sandbox. The sandbox will bring together not just banks, but also enterprises with IPs, valuation experts, insurers, legal, and other professionals to test the whole life cycle of IP financing. It will be an interactive and iterative approach. And our goal is not just to test out individual transactions, but also to identify any operational challenges, to explore possible solutions, and also to share good industry practices. All these initiatives allow us to turn innovative ideas and insights into action. We are committed to fostering resilient and future-proof bank financing for SMEs. And there are 3 aspects. First, we work closely with banks to find the right balance between securing credit flow, supporting real economic activities and SMEs, while not undermining or while we are safeguarding prudential risk management. In the same vein, we promote responsible innovation through fit-for-purpose regulations and risk-based supervision. Second, we encourage banks to be more agile and innovative to support the evolving needs of SMEs. So that's why our sandboxes approach is a game changer. This allows us and banks to pilot new ideas, to scale approaches, and to co-design the guidelines for future financing together, so benefiting both the banks and SMEs. But innovation is not possible without collaboration. So from banks to tech firms to legal experts, insurers, regulators, and SMEs themselves, no one can do this alone. Collaboration can foster greater success in the innovation and transformation of businesses, financing, as well as the greater economies. So if I were to sum up the HKMA's approach to promote access to credit, it is these three words: equilibration, innovation, and collaboration. Thank you.
Thank you very much, Ms. Chu. Now, from prudential banking and sustainable access to credit, we pass to intellectual property financing. And I will kindly ask Mr. David Wong to go ahead. Thank you.
Professor Castellano, fellow speakers, distinguished guests, ladies and gentlemen, good afternoon. Thank you for the kind invitation to speak at this distinguished gathering of local and international leaders. This is the 8th edition of a vital conference made possible by a network of key international organizations. I hope my presentation on the latest development in Hong Kong will make a contribution to this global dialogue. I need not repeat the importance of intangible assets in today's economy. My presentation will focus on the policy context in Hong Kong for exploring IP financing in our economic development. I will start with my own department. The Intellectual Property Department is a professional agency of the government of the Hong Kong Special Administrative Region, comprising IP lawyers and examiners. We report to the Commerce and Economic Development Bureau as our policy bureau under the Financial Secretary, who also oversees the whole economy, including the innovation and technology side and financial services. My department is responsible for three things: giving professional advice to our policy bureau to formulate policy and legislation on IP. Second, administer the registration of trademarks, patents, and designs. Third, promote protection and use of IP. So in sum, we aim to foster an environment where creativity can flourish and hard work can be rewarded. Next, come to our IP regime. IP, as you all know, are creations of the mind. They have no physical presence and cannot be protected by physical possession. They can easily be reproduced at very low cost. So effective legal protection of these intangibles as private property rights is all the more important. Under the one country, two system framework, the Hong Kong Special Administrative Region runs a separate common law jurisdiction, a strong rule of law tradition. Our courts exercise judicial powers independently. Both English and Chinese languages are official languages. Together with the Macau SAR, Hong Kong enjoys the unique advantage of one country, two systems, three jurisdictions from a legal perspective, connecting China and the rest of the world. In terms of IP, we run a robust system that enshrines the international standards. Major international IP treaties, such as the Paris Convention for the Protection of Industrial Property and Convention for the Protection of Literary and Artistic Works, and the Patent Cooperation Treaty, are extended to Hong Kong through our motherland as a constituent party to such treaties. As a founder member of the World Trade Organization, Hong Kong has implemented the agreement on trade-related aspects of intellectual property rights. It's an integral part of our multilateral obligations for over 3 decades. Domestically, we have enacted specific ordinances to protect patents, trademarks, designs, copyrights, layout designs of integrated circuits, and plant varieties. Topics of case law also recognizes other IP rights, such as confidential information, domain names, and business goodwill. So together, they form a solid legal foundation for economic exploitation of IP. Importantly, in the context of today's discussion. Our law generally recognizes IP as a private property right that is capable of being transferred by assignment, licensed for use, and pledged as a collateral. Notably, our legislation specifies that charges on IP be registered the Patents Registry, Designs Registry, and Trademark Registry of my department, as well as the company's registry. So the policy context. To drive economic development, countries around the world embracing the concept of knowledge economy. China's reform journey has been firmly racing in this direction. We surely can know more from the series of 5-year national plans promulgated over the past decades. The latest 15th 5-year plan, covering 2026 to 2030, is in the making. So in terms of the national plans, Hong Kong has been pursuing ambitious policy across different areas. First, we have been investing heavily to establish Hong Kong as an international innovation and technology center. Over 2 terms of government until now, we have invested more than $25 billion to develop a vibrant I&T ecosystem in Hong Kong. With the significant input on the R&D side, we are increasingly focusing on exploiting the outputs, making use of the technological know-how and the patents register. For example, the government has recently announced 3 separate schemes, which worth over $1.2 billion to spearhead such developments. Second, we are relentless in promoting our cultural and creative industries. For decades, Hong Kong has been a regional powerhouse in producing creative goods and services, such as movies, TV programs, songs and music, and pop concepts, inspiring cultural exchanges across China and other parts of this region. We are adamant to build on such foundations to climb new heights. The cultural contents embedded in these creative outputs can be commercialized through the protection of copyright, trademarks, and designs. In this way, we harness market forces to promote cultural interflow, contributing to Hong Kong's position as the East-West Center for international cultural exchange under the current national 5-year plan. Third, Hong Kong plays an instrumental role in the Guangdong-Hong Kong Greater Bay Area, which comprises 2 special administrative regions and 9 most vibrant cities in the Guangdong province, with a total GDP of over $2,000 billion. According to WIPO, the World Intellectual Property Organization, its latest Global Innovation Index 2025 ranks the Shenzhen, Hong Kong, Guangzhou cluster as the first among the top 100 innovation clusters worldwide. For the last 5 years, together, we filed 2,292 patent cooperation treaty applications, published 3,775 scientific articles, and had 135 venture capital deals for 1 million inhabitants. There is also a vast consumer market, the total population of over 87 million. So there exists a great demand and supply of intellectual creations on both the technological and cultural sides. With a world-class bilingual service sector endowed with deep market insights and cultural linkages, Hong Kong plays the dual roles what we call super connector and super value adder on the 2-way platform, bridging China and the rest of the world. The policy blessing is apparent in the 15th five-year plan proposal released earlier this month. So against the above policy background, IP clearly plays a very critical part in our next stage of economic development. Our vision is to drive Hong Kong as a regional IP trading center. IP trading is a concept that encompasses the creation, identification, protection, management, commercialization of IP rights, and includes business activities such as transfer of rights, licensing, franchising, etc. Our efforts in promoting the development of the innovation private sector and the cultural and creative industries are deeply connected to the idea of IP trading. Series of initiatives in recent years can serve as illustrations. In 2022, we updated the copyright ordinance to provide for a new exclusive right of communication of copyright works to the public, putting the streaming of music and audio-visual works on the internet on a strong legal footing. An exercise is underway to consider further amendments to take into account the rapid development of artificial intelligence, balancing the interests of copyright owners and AI developers. In 2019, we amended the patents ordinance and started a new route of obtaining local patent protection through substantive examination of the scientific inventions by Hong Kong's Patents Registry. The reform is underway in a bid to achieve examination autonomy across all major technological sectors by 2030 as a cornerstone of our local I&T ecosystem. In collaboration with the China National Intellectual Capital Administration and the World Intellectual Capital Organization, we are setting up the first technology and innovation support center in Hong Kong as part of a 200-strong network across China to provide local SMEs and entrepreneurs with high-quality IP information and services and assist them in exploiting the innovation potential. And we have implemented the patent box tax incentive, which reduces the tax rate on profits derived from eligible IP rights from the existing 16.5% to 5% to encourage the industrial and R&D sectors and IP users to engage in more IP trading activities. And of course, we work to promote IP literacy across the economy, such as organizing IP training courses and international IP conferences. So further down the road, our focus is on supporting IP-intensive industries to access finance to grow and develop. According to a study my department has done, between 2019 and 2021, IP-intensive industries contributed about 33% of Hong Kong's GDP and 29% is employment. Employees in IP-intensive industries generally earn a higher income than those in non-IP-intensive industries. Hong Kong ranks third globally as an international financial center. Our financial services always plays a critical role in supporting our economic development. A vibrant equity financing landscape is evident. For example, we are Asia's largest and the world's second largest fundraising hub for biotech companies, with 78 pre-revenue or pre-profit biotech companies listed in Hong Kong since 2018. But as enterprise grows and sees innovation results, founders will become less willing to trade ownership for funding. That's financing naturally make business sense. But using IP as a security is underdeveloped globally, including Hong Kong. There are various challenges, such as lack of understanding of IP as an asset class and difficulty in valuation. Our banking industry is prepared to explore new business opportunities. The government also has a role to play. Just in October, our chief executive, in his policy address, announced a series of support measures with the aims of bridging knowledge gaps, gathering data and experiences, and building confidence. So with the Commerce and Economic Development Bureau taking the policy lead, we will do a number of things. We will collaborate with the Hong Kong Monetary Authority to launch an IP financing sandbox to assist the technology sector in leveraging IPs for financing, with the support of the banking, valuation, legal, and other professions. We will support the Hong Kong Technology and Innovation Support Center in providing a new service to SMEs to evaluate the quality of their patents based on national standards. We will launch a 2-year pilot program to provide funding support for patent valuation by professional service providers as a reference for financing. We will support local enterprises to compete for the China Patents Award, one of the highest honors in China's IP sector. And last but not least, we will organize IP training courses for banking practitioners. We will also ride on our annual flagship event, the Business of IP Asia Forum, which will be held next week, the 4th to 5th December, to promote IP financing. My deputy, Thomas Zhang, will have more to say on this front tomorrow in the morning sessions of Unlocking Innovation, Intellectual Property Collateralization. In sum, going forward, we hope our pioneering steps can shine light on a new path for IP-intensive SMEs to bridge their financing gap and unlock the value of the IP. So let me pass the floor back to Professor Castellano. Thank you.
Thank you very much, Mr. Wong. Well, we have seen that intellectual property, IP in general, integrates in a broader policy context. Yet to make it become as a viable asset class, more needs to be done. And more needs to be done in a sense of coordination in order to ensure the possible collateralization. In other words, similar to what we have seen this morning, even having a perfect law might not be enough if there is not an effort of coordination, and that's what from the IPD we have learned. Now, from this asset class, we move to another asset class, showing the need for coordination, and in particular, I kindly ask Ms. Hazel Lowe to tell us about digital assets.
Good afternoon, everyone, and thank you, Professor Castellano, for your invitation to speak in this conference. So in the next 10 to 15 minutes, I will walk you through the key features of the SFC's regulation of digital asset custody and tokenization. Before going into digital asset custody and tokenization, I'll just explain to you what we mean by digital assets. Digital assets involve virtual asset, which means Bitcoin, Ether, and also includes stable coins. And it also includes tokenized securities. And tokenized securities is just traditional securities with a technological wrapper. So it's like a wrapped up securities, but underlying is still traditional securities. And I will also give you an overview of how the SFC regulate digital assets. The SFC identified since 2018 the risk of virtual asset is actually not just related to money laundering, but also involve investor protection concerns. So we introduced a comprehensive framework to regulate virtual asset related activities. We adopt the same business, same risk, and same rules principle for our regulation of virtual assets. This means that if the virtual asset activities, we treat it similar to how we regulate traditional brokers and dealers, and we make necessary adjustments to the regulations to cater for the risks associated with virtual assets. So one of the challenges we faced back in 2018 is the limitation of our statutory powers. Because the SFC is traditionally a securities regulator, and our powers come from the Securities and Futures Ordinance, and virtual assets may not be securities, although some of them may be underlying, may have some securities element. So we create an opt-in approach, which means that if a crypto exchange, they are willing to trade one security token, then they can fall within the SFC's regulatory remits. But applying to our Type 1 license on dealing in securities, as well as Type 7 license on automated trading service. Apart from crypto exchange, we also regulate other activities of our licensed intermediaries relating to virtual assets. These include advisory, distribution of virtual asset related products, asset management, and also virtual asset dealing. So over the years, we have issued a lot of statements relating to initial coin offering, security tokens offering, and also NFTs. We warn investors of the risks of investing into these offerings or products. As we see a growing interest in tokenization of securities in Hong Kong, we have issued 2 circulars relating to tokenization in November 2023. We also issued guidance on virtual asset futures, exchange traded funds, and virtual asset spot ETFs. We have issued a roadmap in February this year that is called the Aspire Roadmap. It is a strategic plan to guide Hong Kong's growth as a trusted and innovative center for virtual assets. Aspire stands for assets, safeguards, products, infrastructure, and relationships. And these 5 pillars form the backbone of 12 key initiatives that shape how our market develops. And we always want to keep a balance between opportunity and investor protection. The SFC is a core member of the steering group of the IOSCO FinTech Task Force, and we actively participate in thematic review of assessing the compliance with the recommendations for crypto and digital asset markets. And the findings were issued in October 2025. Now, let's take a deeper look at how we regulate virtual asset custody. With the Anti-Money Laundering and Terrorist Financing Ordinance amended and take into effect on the 1st of June 2023, all centralized crypto exchanges trading virtual assets operating in Hong Kong or actively market their service to Hong Kong investors will need to be licensed by the SFC under this ordinance. In terms of regulation requirements relating to virtual asset trading platforms, one of the important focus is safe custody of assets. As with all SFC licensed intermediaries, a licensed platform is required to segregate client assets from house assets. We require the virtual asset trading platform to set up a wholly owned subsidiary, which is the associated entity, to be the custodian for its clients' virtual assets. As custody of virtual assets primarily concerns the safe management of private keys, licensed virtual asset trading platform, they are required to establish and implement written internal policies and governance procedures for private key management to ensure all the cryptographic seeds and keys are securely generated, stored, and backed up. And it should also have appropriate and effective procedures to protect client assets from thefts, fraud, and other misappropriation. Further, a virtual asset trading platform, they need to have in place compensation arrangement approved by the SFC. We require them to cover potential loss of 50% of client virtual assets kept in cold storage and 100% of client virtual assets in hot storage. Hot storage means storage which is not connected to the internet. And the compensation arrangement could include any combination of third-party insurance, funds, or virtual assets of the platform operator or its group company. And we also have our requirements relating to hot storage of virtual assets. The hot storage cannot be more than 2% of the total virtual assets kept by the virtual asset trading platform. And we also have restrictions on lending, pledging of client virtual assets, and also require the virtual asset trading platforms to whitelist the client wallets. We have issued a circular on expansion of products and services of virtual asset trading platform on November this year. And through this circular, we allow our virtual asset trading platforms through the associate entities to provide custody service for digital assets which have not been made available for trading on the virtual asset trading platform. This expands the services of our licensed virtual asset trading platforms. The requirements for these virtual asset trading platforms, if they want to provide custody service for virtual assets which are not traded on them, they will need to comply with existing requirements under the virtual asset trading platform guidelines, as well as the tokenization circular, especially the custody-related requirements when offering such services to their clients. For example, a virtual asset trading platform, they should continuously assess and monitor the relevant developments of security threats. And also they must ensure that their internal control, technology infrastructure, and anti-money laundering monitoring and market surveillance tools can effectively manage any risk specific to these digital assets. The SFC has launched two important public consultations in June this year. One on virtual asset dealing and the other one on virtual asset custody. These consultations aim to gather views from both the industry and the public on how Hong Kong should regulate the buying, selling, and safekeeping of virtual assets. And the consultation has closed at the end of August, and we are now working on the consultation conclusions, and we aim to issue the consultation conclusions at the end of this year. In relation to virtual asset custody, we propose to regulate the custodians, which by way of business responsible for the safekeeping of virtual asset on behalf of clients or instruments enabling transfer of virtual assets of their clients. This would include our virtual asset trading platforms, banks, subsidiaries of banks, and store value facilities, as well as virtual asset fund managers providing custody service. In terms of regulatory requirements, we will model them based on those applying to our current virtual asset trading platforms. There will be requirements relating to financial resources, professional knowledge and experience, risk management practices, financial reporting disclosures, and conduct of business. Our particular focus is on how licensed players manage their risks relating to private keys. And we expect to license only the most robust and reliable players in the market to ensure a secure environment. The public is generally very supportive of the proposed regimes for VA dealers and VA custodians. And we are now considering to expand the scope to cover virtual asset advisory as well as virtual asset management. And we are in discussion with the government. Now let's turn to tokenization. Over the past few years, the SFC has noticed an increasing demand from the traditional financial institutions to experiment with tokenization. Our perspective is that tokenization is generally just a technology wrap, and it's just an infrastructure around the traditional instruments. such as funds and bonds. And it does not actually change the nature that it is still a security. So they should be regulated as such in its primary offer and secondary market trading. We see the potential benefits of tokenization to the financial markets, particularly in increasing efficiency of product life cycle, enhancing transparency, and the potential to reduce settlement time, and the potential use as collateral for financing. So in November 2023, we issued 2 new circulars to provide guidance to the industry on tokenization of securities. One on the tokenized securities related activities, and the other one on SFC authorized investment products. Our guidance focus on due diligence obligations on the intermediaries, in particular, how they address the risks relating to the use of distributed ledger technology and how the technology affect ownership rights and are recorded and transferred. And also they need to take into account issues such as settlement finality, as well as some technology risks. For example, if smart contract is used, they should conduct smart contract audit to make sure there is no bugs, and when they deploy the infrastructure, everything is ready. In relation to custody of tokenized securities, we expect effective measures are in place to protect client assets, such as administrative controls for transfer restrictions, whitelisting of client wallet addresses, and also particularly when the tokenized securities are on public permissionless networks, because they are more susceptible to theft. So I hope this will give you a brief overview of our regulations relating to virtual asset custody and tokenization. The SFC will continue to closely monitor the latest developments in the digital asset space and refine our regulatory requirements to cater for market development while balancing the risks and also ensuring investor protection. Thank you.
Thank you very much, Ms. Low. So we are in our journey of different type of intangible assets. We have effectively seen again that when we are talking about digital asset, at least a certain part of it, what private law digital asset might be broader, but a certain part of it, in particularly crypto, fall within the regulatory pyramid. And that is actually a fundamental problem whenever we are dealing with secure transaction and secure lending, because we trigger a series of requirements that will normally will need to be considered. So at this point, after we have seen these other class of digital assets, we actually zoom out and actually have a look at a broader policy perspective that is actually allows what we can call more broadly as intangible based finance in a sense. And to this purpose, I invite Mr. Rocky Tung to take the floor. Thank you.
Thank you. Thank you very much, Giuliano, for inviting me to be here. Like Carmen, I also graduated from the Hong Kong U, although, I only did a very short degree here, but, it's good to be back. Unfortunately, it's a very sad day for Hong Kong. All of us are pretty troubled by what happened in Taipo yesterday. So I guess, a lot of you who are aware of what happened, is the worst fire that's ever broken out here in Hong Kong. Has already killed 44 people and almost 280 people still missing. So I hope you guys can bear with me. If I can't deliver what I'm supposed to deliver, please excuse me. So before I start talking about what we at the Financial Service Development Council has prepared for this session, I would like to just highlight that Hong Kong, unlike some other jurisdictions, we do not discriminate incoming or existing players. So what it means is really that although we hope to have more businesses coming to Hong Kong, establish their presence and continue to do business here, we don't want to incentivize them to be here.
we want to obviously apply the same kind of policies for them to be landing here. And at the same time, we are, like providing the stimulus support that we have for existing players. Just that part, it's not really discriminatory. We also adopt a very prudent approach of doing things. The prudent approach is necessary because at the end of the day, things can go, appear to be very rosy as it comes out. It can be very attractive, but things can turn pretty bad. And that is also the other thing that I want to highlight. And Hong Kong really does adopt that kind of approach. And the third bit is that it's explanatory in the sense that we have seen regulators, both of the most important regulators of different functions are present here today. We have seen a pretty restrictive approach to certain regulated activities at the outset, but we have seen the expansion of scope and allowance of activities to be carried out in Hong Kong afterwards. And I think this is this should be better understood by people coming from different places, because that is the only approach for us to manage risk more proportionately, and at the same time allow business opportunities to evolve over time. Now, then it allows me to go to what cover two topics that are already covered by my fellow panelists. First is about Hong Kong, whether or not we are a digital asset hub. Obviously, for many of us who know us and ourselves very well, we know our regulatory framework, we know what we're doing, we know the activities in Hong Kong, and we ought to think we are doing pretty well, but there are other people who may or may not consider it to be the case. For instance, this report by GFTN took a look at what we are doing and realized that in terms of tokenization, it may not be having such a clear framework enforced at this juncture. Whether or not that is the case, I think it is debatable. Whether or not some other jurisdictions where they consider, for instance, staking is permitted, there are, like ambiguity for many other participants that we have discussed with. So, we are not trying to neglect criticism, but we are mindful of the differences in terms of our perspectives into the same issue. This is already covered by Hazel earlier, and so I'm not going to repeat it. But this really goes back to what I mentioned earlier. We, at the outset, try to be pretty prudent in terms of activities regulated, and in terms of granting license. This is necessary, right? Like I don't think at that point in time there were very clear guidances in other jurisdictions as to how they would like to regulate decentralized or distributed finance. It's almost binary at that point in time, where some people considered it good, other thought that it was some criminals dealing with it. To Hong Kong, we adopted a prudent approach to regulate institutions who are having a little bit more exposure than manageable, and therefore, we had the licenses regime for not only the asset managers but also the exchanges. And also back in 2021, there was a period when the government and the Securities Futures Commission thought it would be good to only permit professional investors to be involved in digital assets or virtual asset trading activities. Then the government, led by the Financial Services and the Treasury Bureau, decided that perhaps it's worth another look into it, and the government wouldn't hesitate to make a turn And that turn is not to be more restrictive, but rather the other way around. It's more liberalized, unlike some of the other jurisdictions who had tried to lure presence of firms to their jurisdictions by over promising the potential of grandfathering approach. And therefore, I think, our approach is more prudent, but it's more liberal. Now, to that end, we are already seeing quite a few development in terms of investment vehicles that consists of crypto underlyings. That we also have quite a few firms already licensed. Some of them are in full operation, others are dealing with it. But it is fine. I mean, like, it's not it is not the government or the regulators take to decide whether or not they are profitable, whether or not they can come up with a business proposal that are profitable. But allow them to do it, and if they can't find it sustainable, they will do something. For instance, some of the firms would try to return the license from the brokers to the storage value facilities. Some of the firms may not want to carry that license anymore. So I think by allowing, having applied the same activity, same risk, and same rule principle across our different regulatory regimes, that would allow people to understand where we're coming from. Here, it's just a slide highlighting some of the acronyms that you have heard from Carmen and Hazel respectively. I think it is fine to have those, but you will need to work with the regulators or the other partners and friends in order to understand it better. But I'm not going to devote too much time on it, too much time to it. Now, positionality really matters to me. I think some of the jurisdictions in the world would consider crypto the best thing since sliced bread. Others, would believe that, CBDC or central bank digital currency is the right approach of doing things. It's more managed, it's more governed, it's better regulated. I think, Hong Kong is an international financial center. It's almost like a supermarket. We can't just sell alcohol or pork or beef or chicken or whatever. We sell snacks too. So we allow, stable coins to be an enabler for this to happen. We have tokenized deposit, we have tokenized money market funds, but we also allow stablecoin, potential stablecoin issuers to leverage Hong Kong's positioning to deal with it the other way. So again, this is something from GFTN. I love it, except that, I do not agree with its assessment all the time. But, having a framework is better than no framework. So I am up for any debate in that regard. Now, in terms of intellectual property trading, this is not something that I'm very good at. As a matter of fact, I'm good at nothing. But I am good at listening to, experts. And so to me, I think it's necessary to establish working groups to listen to friends near and far. We have Giuliano, being a part of our working group, leading our thought leadership. Johnson is also on it. So I just want to highlight that we're listening to the industry as to what Hong Kong should be in terms of positioning ourselves as an intellectual property trading center, so to speak. Obviously, the SAR government, as well as the central government of the Chinese Republic, we have said a lot about this. But what can Hong Kong really do? And it really should look into the typology or taxonomy of what IP really is like. It starts with the definition of it. We see trademark, patents, copyright, licensing agreements, and whatnot, trade secrets. Some of these things are more tangible, within the intangible spectrum, right? Some of the things are, already allowing you to make profits or at least, have some streams of incomes. But, others are not necessarily the case. For instance, in terms of patent, yes, there are a lot of universities out there having a lot of patents, but, they would also tell us that some of these patents may not worth much, sometime down the road. So this is this is a very interesting observation that we had gathered so far. Interesting because, although sometimes we do want to emphasize the values of, intellectual property right, like patent. Sometimes, we should really ask ourselves, can we really do it? Can banks do it? Can the partakers or investors, really want to get involved in it? So these are some questions, initial questions that is for us to have, throughout the research process. We also, have to notice that in terms of being a center, in the last couple of weeks in November, we published a couple of papers. One is in relation to commodities. The other is about art collectible financing. The FSCC publish papers every now and then, like roughly 8 papers every year. But the idea is really for us to look at the, root cause of some trading activities and how it attributes to the accumulated value of the economy. What I wanted to get at is, interestingly, for both of these papers, we realized that talent is a very important element. Now, I think it is the same for IP. We need to have people who are good at, or at least demonstrated experience and expertise in, evaluating, some of these IPs. So I think it may not be here yet, but I think this is some missing component that we should look at as we move on in terms of our project. And last but not least, I think Hong Kong does have some advantage comparing to the other counterparts. David has already mentioned it, one country, two systems, and we have a lot of freedom in terms of movement of paper, capital, information, etc. Now, the last bit of it is really that we have people who are trusted and entities who are trusted by our counterparts from around the world, from mainland China, the Chinese mainland, to the other places, and therefore, we should find a way to leverage and ride on such advantages. I think industry associations and think tanks would also need to play a very good and important role in this journey. And with that, I think I'll just, these are some very preliminary thoughts, and I just want to put this out, and hope all of you will enjoy the rest of the couple of days in Hong Kong. Thank you.
Thank you very much, Mr. Tone Rocky. Well, we see that actually there is a broader policy effort. And then when we are really thinking about taking these assets as collateral, intangibles, we do have to think a bit broadly and a bit behind the specific, let's say, secure transaction rule, or beyond the specific type of private law element. We will hear more about that and the importance of this in other panels, and also we will dig into these elements. But this gave us a broader view, and I would like to complement this general comprehensive view that we have had about Hong Kong by offering the example instead of Japan, where actually we do have cases of the digital asset-based lending. And then for this, I will ask Mr. Mitsutani to join us from the screen.
Thank you. Thank you very much. Good afternoon, distinguished colleagues. I'm Tomi Mitsutani, working at the Japan FSA, the integrated financial regulator in Japan. I'm delighted to have this opportunity to speak as part of this excellent panel. I would have preferred to join you in person, but I apologize for participating online. I still have some Hong Kong dollars from the trip I took as a university student, and they haven't had a chance to make the appearance yet. But anyway, it is a great honor to join this great panel. And thank you very much for this opportunity to present Japan's recent secure transactions law reform, with a particular focus on an underexplored dimension, the intersection between digital assets and the enterprise value charge. My presentation takes a somewhat different approach from the preceding panelists and incorporates an introduction to the Japanese secure transaction law reform. I will appreciate your indulgence as I develop this perspective. So I would like to begin with a nuanced observation about Japan's approach to digital assets. Please look at the first item, 01 on the slide. While Japan has enacted specific regulations, we lack a unified, comprehensive legal framework for digital property as a whole. The legal characterization of many digital assets, including NFTs, digital rights, and emerging forms of digital property, remains dependent on case-by-case interpretation. This fragmented approach creates uncertainty for market participants seeking to leverage these assets for financing. Yet this legal ambiguity, digital assets are actively traded and monetized in our economy, so which means possessing real economic value. And on the other hand, the enterprise value charge was primarily designed to modernize Japan's lending practices, particularly to enable cash flow-based lending for small and medium enterprises. However, an interesting byproduct of this comprehensive framework has been the emergence of new pathways for collateralizing digital assets. So as pointed out in the item 02, the EVC enterprise value charge encompasses the totality of an enterprise's assets, tangible and intangible, present and future. When enforcement occurs, court-appointed trustees manage and monetize all assets to preserve enterprise value. Through this comprehensive approach, the EVC has partially opened a path for digital asset collateralization, even without precise legal definitions. The market, through the trustees' monetization process, can determine what these assets are worth. While this was not the primary intent of the reform, it represents an intended yet potentially valuable consequence. So it could be said a partial solution to the digital asset collateralization challenge has emerged from a broader secure transaction reform. So what are the contextual drivers for this reform? So the EVC reform responds to structural changes in the Japanese and global economy. Please look at the item 03. The primary drivers were the need to facilitate lending to startups and SMEs, address Japan's business succession issues, and provide better restructuring tools. As enterprises increasingly derive value from intangible assets and future cash flows rather than tangible property, so traditional asset-based lending has become increasingly inadequate. International assessments highlighted these limitations, with Japan ranking poorly in global credit assessment metrics. So World Bank Group Doing Business 2019, Japan ranked 94th in 290 countries. So the EVC represents our response to these challenges, aiming to modernize our secure lending framework for the 21st century economy. The potential application to digital assets, while not primary driver, represents an interesting additional dimension of this reform. So based on economic analysis and stakeholder consultations, we anticipated three primary use cases. First is venture debt financing. Technology companies with valuable intellectual property but limited tangible assets may benefit from comprehensive security over enterprise value. The incidental inclusion of digital assets in this comprehensive security may prove advantageous, though this remains to be tested. And acquisition finance. Japan's demographic challenges create urgent succession needs, potentially facilitated by ABC secured leveraged transactions and corporate restructuring. The post-pandemic economy requires sophisticated restructuring tools that preserve going concern value rather than forcing liquidation. So then please go on to the next slide. Let me now articulate how contemporary scholarship informed the EVC's specific legal architecture. So for example, Professor John Armoth, Oxford University professor, framework identifies some key functions of security interests. First, ex-ante bounding that constrains debtor opportunism, and also coordination mechanisms preventing value-destroying creditor races. And lastly, ex-post enforcement procedures preserving going concern value. These insights, which Professor Emeritus Hideki Kanda of the University of Tokyo also emphasized in earlier scholarship, are directly reflected in the ABC's statutory design. Then moving on to the legal architecture and the core features, item 05, the enterprise value charge framework established under the Act on the Promotion of Cash Flow-Based Lending comprises nearly 300 provisions integrating elements from multiple areas of Japanese law. So given the reform's recent enactment and pending implementation, the following features represent the intended design, though practical application will inevitably shape their interpretation. So first is comprehensive coverage, asset coverage. The Act's provisions established AVC coverage over all enterprise assets, real estate, movable property, intangible assets, and future cash flows. So to reiterate, this scope was designed to capture enterprise value comprehensively for traditional lending purposes. Incidentally, this comprehensive approach may also capture digital assets whose legal status remains uncertain, though this was not a primary design consideration. So how courts and practitioners will handle novel asset categories remains an open empirical question. And second is perfection and priority framework. The EVC employs legislation and the restoration in the debtor's commercial registry for perfection, establishing priority through a first to perfect rule. This registry-based approach aims to provide transparency and legal certainty, though its interaction with the existing security interests will require careful judicial development. And enforcement and value preservation. So the enforcement mechanism centers on court-appointed trustees with authority to manage debtor assets and operations. These trustees may, with court approval, continue business operations and satisfy critical claims necessary for value preservation. While this framework is designed to preserve going concern value, its effectiveness in handling complex digital assets will only have become clear through practical application. And more on to the risk mitigation functions. The EVC operationalizes the bounding function by invalidating non-ordinary course transactions without EVC holder consent. This creates a legal commitment device that constrains opportunistic asset stripping. The EVC implements coordination function by empowering EVC holders to stay individual credit enforcement actions, preventing collective action problems, which Professor Armour identified. So also the trustee enforcement mechanism, with its emphasis on going concern preservation, directly implements the value preservation function. This represents a deliberate translation of economic theory into statutory mechanics. So before closing, let me talk about the Financial Services Agency's role in developing this framework. So then the Japan FSA Financial Services Agency has played 3 roles in this reform process. First was a central role in legislative development. The AVC represents an unusual case of close collaboration between financial regulators and justice authorities in law reform. While security interests traditionally fall under the Ministry of Justice's jurisdiction, the FSA played a central role in developing this legislation due to its direct impact on lending practices and credit risk management. So this collaborative approach with the FSA and the Ministry of Justice working as partners brought together to legal expertise and practical market knowledge. The FSA's understanding of legal lending practices, risk management frameworks, and market dynamics complemented the Ministry of Justice's legal expertise. This partnership aimed to create legislation that is both theoretically sound and practically implementable. The second is incorporation of regulatory elements. The Act incorporates significant regulatory elements into what is fundamentally private commercial law. AVC holders must obtain FSA licensing, subjecting them to ongoing supervision and quality control. This represents more than simple administrative oversight. It shapes market participation at a fundamental level. For example, this regulatory gateway can prevent unsustainable parties, such as organized crime syndicates, from utilizing the AVC mechanism. Only legitimate financial institutions can exercise these security rights. So this incorporation of regulatory safeguards into private law structures represents an innovative approach that warrants careful scholarly analysis. So lastly, credit risk management framework. The FSA has developed comprehensive guidance on credit risk management for AVC secured lending, drawing on international analysis of collateral functionality. And our framework enables lenders to manage AVC secured exposures in separate categories, with particular attention to future cash flow potential rather than solely historical asset values. This forward-looking approach aligns with the AVC's fundamental purpose, enabling lending based on enterprise potential rather than past accumulation of tangible assets. So then implementation begins next May, and both opportunities and challenges. The FSA is conducting practitioner training focused on critical questions, covenant design for diverse industries, and borrower communication strategies. These efforts aim to foster a gradual transformation in Japanese lending culture, though significant challenges remain. The shift from asset-based to cash flow-based lending requires not merely legal reform, but fundamental changes in credit assessment and risk management practices. And in conclusion, I'd say the enterprise value represents an ambitious attempt to modernize Japanese secured lending for contemporary economic needs. While primarily designed to address traditional lending challenges, SME financing, business succession, and restructuring. The ABC's comprehensive approach has created an unexpected opportunity by encompassing all enterprise assets without requiring precise legal categorization. The ABC has partially opened a path for securing digital assets, even as their legal status continues to develop. And also, the FSA's multifaceted involvement in legislative development, regulatory design, and risk management guidance reflects the complexity of this undertaking. While the theoretical foundations are robust and legal architecture comprehensive, the true test will come through market implementation and judicial interpretation. So what we can say is that Japan has undertaken a significant experiment in secure transactions law, one that primarily addresses traditional lending needs, while incidentally creating new opportunities for the digital economy. So with that, that is the end of my report from Japan. Thank you very much for that attention.
Thank you very much, Tomio-san. We really appreciate it. And actually, I think the last point, the idea that actually the law reform needs to coordinate with a broader set of market and regulatory elements is what exactly we are trying to tease out and then further elaborate for the rest of this conference. Now, abusing immediately of my moderator role and host role, I actually take just the chance to ask a couple of questions very quickly and probably going slightly over 5 minutes over the allocated time, and so your coffee. So with the first point is really a burning question, and something we have been seeing a lot and in different reform projects where we are trying to implement international standards, where we are coordinating with the definition of secure transaction law, is banking capital requirements. And then, Ms. Chu, I'm looking at you here. So whenever, even in a normal context, whenever we're looking at tangible collateral, movable asset as collateral, there is the tendency in some jurisdiction more than another, then actually not to consider it as an eligible collateral. In the context of intellectual property and then digital asset and the intangible asset, the things that we've been talking about, there is a concern for the coordination with Basel capital requirement and Basel III. Of course, this international standard must be respected, adhered to, because that's the credibility of the system. But how do we manage that? How the MA, for instance, would address these coordination element?
Thank you, Giuliano. So you have actually pointed out very rightly about the Basel III capital framework, which mainly focuses on physical and financial assets as collateral. While for intangible assets, including the IPs, these are treated differently. But let me just provide a little bit more background of the Basel III. Now, the banks under the Basel III framework have to maintain sufficient high quality assets to absorb shocks and potential losses. And so being a member of the Basel Committee, Hong Kong, and actually other members like the UK, like Chinese mainland and Singapore. So we all actually are committed to implementing the Basel III. And so we in terms of regulation, first of all, so in Hong Kong, we are on par with our other peers, other financial centers. And then based on review on the practices of the implementation of the Basel III, so in other jurisdictions where there are actually IP financing activities, those areas actually also implement Basel III capital requirements, and there was no sort of like relaxation of the requirements in order to promote IP financing. But notwithstanding that, the banks in Hong Kong are not precluded from providing IP-backed financing. And that's the whole idea behind the IP financing sandbox that the HKMA working together with the IPD and then the government to provide this risk-controlled environment where it's not just the banks, but also other stakeholders, including like the valuators, the legal experts, and tech firms and all the other stakeholders to innovate financing arrangements. And from that sandbox, we hope to be able to pilot so that there will be experience from how to do innovative IP financing. And then we hope that we can identify any elements in the ecosystem that needs to be enhanced in order for further development of the ecosystem. And of course, there will be like insights and good practices that we will get from the sandbox, and that will be shared so that we hope that through collaboration, through innovation, that we can like enhance this IP trading and hope that it will underpin the Hong Kong as an international financial center.
Thank you very much. This is, it resonates with the experience, for instance, that I had the pleasure to have with my colleagues here from the EBRD or the IFC, the idea that actually there is a product focus reform strategy in a sense that we start to pilot things rather than relaxing regulation because the market needs to be developed within a system that is aligned with international standard for credibility. But this leads us to another point that is actually the creation of market. We mentioned, the need when we're talking about intellectual property, especially, we're talking about the need for a secondary market, the needs for developing a market. And one point that Director Wong, I think it was particularly important, it was the fact that we mentioned the capacity building, right? The need to train the market and the need to explain the IP training. And I think that's very important, and I will ask you maybe to elaborate a bit more on the role of the IPD in this area, because unlike other secure lending, when we talk, of course, about educating lenders, when it comes to IP, it seems also that we needed to educate borrowers. So to potential borrowers, in a sense, or SMEs, to have a proper IP system. If you can elaborate on that, on the role of the IPD, it would be great.
Thank you, Professor. This is a good question. I think capacity building is an important part of my department. As I mentioned, one of our roles is to promote the protection and use of IP. But IP is a least understood asset among many people. We need people to really appreciate the value of IP and appreciate the creation and identification of IP. When we talk about IP that across different spectrums, I talk about innovative technology sector, we're talking about scientific inventions. So then we have to consider whether it's a genuine new invention on top of the prior art. And we need people who are skilled in both technology and in the knowledge of patent law. And we talk about copyright. No registration is required. It's about works, music, songs, books, novels, animation, and how to prove the ownership. And as a songwriter, how can I know I own the copyright of the things I write? And for general business people, business school is very important. And more often than not, your business school is protected by logo, by trademark, identify your goods and services. But what's the myth of trademarks? Is the trademark here, is it valid outside Hong Kong, in other jurisdictions? So we need to educate people about what IP actually is. And one thing I've been doing is doing this IP manager scheme. We encourage enterprises in Hong Kong to appoint one dedicated staff members as the IP manager, who is trusted with the role to really identify IP owned by your enterprise, to protect your IP by registrations or other means, and to manage your IP, and best of all, to commercialize IP in the days to come. So we provide training courses to them. And other thing is we are doing is the patent talent. because we have invested a lot of resources into the innovation technology system in Hong Kong, we have many science graduates who understand science, understand research and development. But when they create something, they have to really appreciate whether the invention they're creating is a new invention or they are inventing old things. Maybe I invented that before. So we need to really teach them patent law and practice, and general IP law. And we are actually doing a plan to regulate the kind of people, the professional service provider, what we call the patent attorney or patent agents. These are the people who possess double knowledge in both technology, specific discipline, biochemistry, electronics, AI, or whatever, and also patent, IP law, and practice. So we are doing this kind of regulatory arrangements. We're planning for that, and we hope to really groom a pool of people in Hong Kong who can help our enterprises to climb the value ladder. Thank you.
Thank you very much. I think this gives us a closure, a view. There will be other questions that will be interesting, including, and I'm pointing this because maybe we can discuss it over the coffee, what are the custody requirements when, for instance, digital assets are taken as a collateral for when, if there are, we're talking about licensed financial institutions. And this is something we'll give probably a leg to the next panel that, will deal with the future of collateral. So maybe I'll stop abusing the time and then shift the discussion to the next panel and welcome you to the coffee break. But before, please join me in thanking our speaker, and thank you very much.
Thank you, Giuliano. Can we start? So I don't think I need to introduce myself. My name is Jae-Sung Lee. I'm a senior legal officer at the UNCITRAL Secretariat. I had been working on secure transactions, servicing the working group on secure transactions, but now I'm actually servicing another working group. And with me, I have four very distinguished speakers, but old friends as well. I have Teresa, all professors. I have Teresa, Megumi, and Woo-Jung, and also Marek, who's online, who is also a professor. So we have an academic panel, but they also have practice in the actual practice. So it's going to be quite interesting. I think I would like to start with the panel's title, which is Pathway to Digital Secure Lending. And I think one of the questions that we're getting in the context of the UNCITRAL's work is, what is digital trade? Whether it is the subject that is digital, whether it is the means of trade that is digital. And I think the same applies to digital secure lending. I think the description actually focuses on digital assets as the subject of the secure lending, but it could actually mean digital lending, meaning how loans are plotted. It could also mean digital secured lending and how to secure these kind of lendings. So I think there's a lot of different aspects that we can discuss, but we will focus on digital assets as the object of collateral and how they can be treated by different jurisdictions, with the first presentations to be delivered by Teresa, giving us an overview of the law, regulations, and technology. Teresa, you have the floor.
Thank you very much. Yes, thank you so much. Thank you for the invitation. Thank you, Jay. Thank you, Giuliano. And thank you to the university for hosting us in this very important conference. As Jay has already introduced, the idea of my presentation is to set the scene for this panel. And in order to do that, I'm going to divide my presentation in three main parts. The first one is try to devise with you a conceptual framework. It's conceptual, essentially, but it's also terminological. As you will see, we need to define properly before deciding whether we need to make changes in the existing legal framework, what is going to be the terminology that we are going to use, and to which extent this terminology is defining conceptually a different class of assets and what are going to be the implication. The second part of my presentation is going to very briefly give you the ecosystem of the different legal rules, so legal instrument at an international level, that has been already providing for rules dealing with digital asset from a property law perspective, and therefore for the purpose of secure transaction. That is the main goal of our panel. And therefore, the third part of my presentation is going to start suggesting some drafting proposal that might be taken into account in relation in particular to the UNCITRAL model law on secure transaction. So let me please start from the conceptual framework. So we're talking about digital asset. Digital asset as a term has to be framed within a three-layer framework. So digital asset is referring to the new technology that we have developed for the purpose of creating new value, transferring value, or representing value in modern economies. So tokens represent a new vehicle for creating, transferring, and essentially representing or documenting value that already exists. So do we need to regulate this new technology? First question. The second level is, among these tokens that are essentially value in a particular technology format, to which extent private law need to define more narrowly these tokens from the perspective of property law. So which of these tokens are as well asset, and therefore to which extent this asset could be also collateral of secure transaction. And the third level, as Giuliano has brilliantly explained in the previous panel, the third level is to which extent regulation, and in particular financial regulation, is going to expand, or in most of the cases limit, or subject to a specific requirement for the purpose of regulation, this asset, digital asset, that we have already categorized or characterized as securities, option, features, money, etc. So this is the first part of my presentation. Let me just go a little bit in depth. So when we talk about digital asset, this in the previous panel, Ms. Law has used the term tokenization or tokenized in order to talk about the functional equivalence of existing instrument. But let me talk about digital asset in general. It's not crypto asset, it's not cryptocurrencies, it's not digital tokens, it's digital asset. Digital assets are essentially representing a new way to create, transfer, and represent value based on two ideas. The idea that we have a value, and this value, and this is the two pillars, this value is represented in an electronic record. So we have the digital component. But the second component that is absolutely key is that thanks to technology, DLT, but also others, we have control method. So we have the possibility from a purely technological point of view to control this value. And if we control this value, we can transfer the value accordingly. So this is, as you can see, the first level, the technological one. The idea is to which extent the fact that we can represent value in this digital asset, to which extent that means that these digital assets are asset, that they are property. And now we have a private law question. The private law question is, taking into account that these assets, digital assets, are either embedding value, they have value themselves, Bitcoins, cryptocurrencies, or they are representing value because they are linked to other assets, could be movable, immovable, tangible, or intangible, to which extent per se, we can call them asset. And if we call them asset, therefore, this asset can be object of any kind of transaction, including secure transaction. And then, as you can see, we are narrowing and narrowing. The third level is to which extent regulation, financial regulation, characterizing this asset as securities, money, futures, etc., in a way they are defining what is the kind of transaction and on which condition that we can do in relation to this digital asset. In some cases, in my opinion, there are some confusion about what is regulation saying and what are going to be the implications in terms of private law. The fact that regulation is decided to regulate or not within the perimeter of the financial supervision and regulation, that doesn't mean that this particular asset is an asset for private law purposes or not. That's why this pyramid, for me, is the key conceptual framework that we need to go to the next step. What is the next step? Do we already have an ecosystem of different instruments at a global level that are dealing with digital assets? And what I would like to do is to see how this fundamental seminal instrument, they could feed a potential possible or advisable amendment of the model law on secure transaction by UNCITRAL. The key one is definitely the UNCITRAL DAPO. We have been already talking about that, but also the UNIDROIT best practices on effective enforcement on the one hand. Second, UNCITRAL has already developed for many years significant instruments that are going to have an impact on this revision of the model law on secure transaction, if needed. Could be simply an interpretation, systemic interpretation. And the third, if I may, a couple of instruments that the European Law Institute has already adopted in relation to digital asset as security and enforcement against digital asset. So as you can see, the first thing that we can do is let's try to find in this ecosystem of instrument interpretation tools to enhance and to upgrade, if I may say so, the model law on secure transaction vis-a-vis the digital asset. How? This is the last part of my presentation. Drafting proposal. How can we modernize and how can we, or what do we need to modernize in the model law on secure transaction? Essentially, three things. The first one, the scope. Is the scope of the model law covering and including digital asset? First. Second, can we apply the existing priority rules to digital asset, the general one, the specific ones, or we need a new ones for digital asset? And third, because the ultimate aim of a secure transaction from the perspective of the secure creditor is in case of default, in case of insolvency, what I really need to do is to enforce against the asset. I need to guarantee that this enforcement mechanism is working effectively. Okay, so three areas. How can we do that? First challenge. Is the scope of the model law including digital asset? If not, what can we do? Okay, the first possibility is to consider first layer technology. That digital asset is simply about what is the technology we use to represent value. If that is the case, we simply use the principle of non-discrimination. This value, this interest of this right could be in paper or could be in a different vehicle or the different medium, digital token. We don't need to do anything except for maybe saying the sole ground that this is a digital token doesn't mean that we cannot apply the model law. So as you can see, a negative, an indirect way to say there is no reason why we cannot apply the model law. The second possibility is to focus on the idea that at the very end, digital assets are functional equivalent of existing instrument or existing asset. So let's do that. Let's say we find the equivalent and we apply the specific rules for that equivalent. That's it. But that is not enough because we know that there are digital assets that require a residual regime. We know that there are digital assets that are not existing instruments that are already covered by the existing laws. So as you can see, the three drafting proposals could be combined, but they are going to be basically, let's say, triggered by a revision of the conflict of law. Indeed, there are some conflict of law problems that we need to address. Let me just, Jay, conclude with the second and the third, and I hope I will be on time. Second, what about effectiveness and priority rules? The model law on secure transaction, any secure transaction legal framework is based on this idea. I want to guarantee as an erga omnes right that my right is effective vis-a-vis third parties. in order to guarantee priority. How can I put that? In the model law, we have different effectiveness method or effectiveness creating or providing method. Now the question is, if we consider that digital assets are always functional equivalent of existing asset, let's apply the general rules. We don't need to do anything else. Second, if that is not the case, so if we consider that digital asset, because of its own characteristic, they need a different method for effectiveness, control, key and fundamental pillar of the UNIDROIT DAPL, now the question is different. The question is control compatible with other method for effectiveness? And if it's not compatible and there is a conflict, how we are going to apply the priority rules? And this is a fundamental idea because if you take a look of the UNIDROIT DAPL, you will see that some of the provisions are indeed comparing two different effectiveness creating method and giving priority accordingly. But digital asset in principle, they are linked to control as an effectiveness method. Can we apply registry or registration for tokens as well? So as you can see, we need to discuss carefully whether we want to apply the general or the specific, or we need to develop not only new effectiveness method, but also different priority or conflict of priority rules accordingly. And let me just conclude with the third level. At the very end of the secure transaction cycle, we have the stress test enforcement, realization of value, liquidation, repossession. This is the stress test of any secure transaction legal framework. Can we apply that as it used to be? Do we need to reconsider any of the measures or the conceptual or theoretical pillars that we have in enforcement? I would just say two things. There are many things to discuss, but probably two or maybe three that are relevant. The first one is the duty to cooperate of the debtor becomes decisive in the case of digital asset. Second, the role played by intermediaries, and when I talk about intermediaries, I'm not thinking about only the financial intermediaries, but essentially custodian, the ones that play a role not always in the third level regulation, but also in the private law level. So they are not necessarily regulated and supervised intermediaries, but their role is crucial. Third, do we have, as Giuliano mentioned before, secondary market for digital asset in a way that we can very easily realize the value of this asset with the same pricing mechanism and with the same reliability and predictability that we have in other kind of asset? If that is not the case, we need to tweak at least the provision that we have in the model law, and best practices that UNIDROIT is elaborating on the matter could be definitely excellent guidance for this amendment. Thank you very much. Jay, I hope that I did not prolong too much my presentation. Thank you.
Thank you, Teresa. And I think you've outlined all the questions that the Secretariat has to actually respond to the Commission, because the Commission, when discussing this topic and as a future work, wanted to have a little bit of information on this. And I think all the questions that you posed are things that we'll have to answer in due course to the Commission. So with that in mind, I think with those questions in mind, we'll go into a little bit more depth, because when the Commission asked us to look at these issues, we were also asked to look at existing practices of states as well as existing text, which is the UNIDROIT DAPL as well. So I think with that, maybe I can pass the floor to Woo-Jung to start his presentations with a little bit of experience from Korea as well.
Thank you very much. It is my great honor and privilege to present before distinguished leaders in finance and the representatives of international organizations and esteemed scholars from around the world. It is particularly meaningful to discuss digital asset here in the University of Hong Kong, an institution with one of the longest tradition of international engagement and the position at the center of global finance and trade. I think the fundamental purpose of digital asset lies in facilitating international trade and ultimately enabling efficient allocation of resources. I would like to cover the international standards that offer a solution of secured lending using digital asset and propose the specific reform pathway Korea should take to unlock the true value of the digital economy. To understand the urgency of this reform, let us turn to the insight of law and economics scholar Ronald Coase and his seminal work, The Problem of Social Cost. The Coase theorem teaches us a simple but profound truth. Market only function efficiently when property rights are clearly defined and transaction costs are low. If these conditions are met, parties will negotiate efficiently outcome, regardless of the initial allocation of right. However, in the realm of digital asset, many countries, including Korea, are currently characterized by legal silence. The Korean Civil Code does not explicitly define who owns digital asset or how a security interest in digital asset can be perfected. This ambiguity creates prohibitive transaction cost. Lenders cannot be certain whether their collateral is safe from third-party claims or bankruptcy of the debtor. Let us ground our discussion in the traditional paradigm of transfer. Yes, thanks so much. The transfer of ownership of real estate is a formal state sanctions event. It relies on the principle of publicity. The transfer is not legally effective against third parties until it is registered in the public registry. This system offers high certainty, but is slow and administratively high and heavy. Next slide. Yes. Let us think about movable asset, tangible object like machine, inventory, or gold. Here, the law relies on physics. The primary mechanism for transfer and security is possession and delivery. To perfect a security over a movable asset, the transferor must physically hand it over to the transferee. The law assumes that he who holds the object holds the right. Possession acts as a publicity mechanism. If you see me holding the gold, you assume that I have the right to the gold. This reliance on physical tangibility, the ability to touch and hold, is the root of our current doctrinal crisis regarding digital asset. How do you deliver something that has no physical forms? Next slide. This brings us to the example of pure digital information. Before the advent of blockchain, digital information or electronic record was inherently non-libelous. If I send a PDF document to you, I do not lose my copy. We both possess it simultaneously. In this pre-blockchain world, transfer was actually copying. Because of this non-libelous nature, pure information has historically been excluded from property law. You cannot own information or a set of electronic record in the same way as you own a box of gold. This distinction prevented digital information or electronic record from being treated as collateral. Yeah, next step. Blockchain technology revolutionized this paradigm by solving the double spend problem. It created what we call a control shift. When I transfer Bitcoin to you, the blockchain network validates the transaction and ensures that I can no longer spend that Bitcoin. My access is revoked and your access is granted. This technology reintroduces rivalrousness into the data asset without requiring physical form. It mimics the transfer of physical object. I give it to you and I no longer have it. This functional rivalrousness is the key that should allow us to treat data asset as property, distinct from mere information. We must distinguish between pure information, which is non-rivalrous and thus not property, and data assets, which are artificially rivalrous and thus behave like property. I think this is why UCC Article 12 of the United States adopted the term controllable electronic record rather than the data asset. The legal definition focused on the capability of control, the functional equivalence of possession. Next. Under UCC Article 12, control is defined by three exclusive powers: the power to enjoy the benefit of the asset, to spend or to use it, the power to exclude others from using it, the power to transfer these powers to other person. Under UCC Article 12, a creditor can perfect its security interest by establishing control, for example, through a multi-signature wallet arrangement or a smart contract escrow. Protection by control gives the creditor super priority over other claimants who might have perfected only by filing. The solution lies in modernizing our definition. Since we cannot physically possess information or electronic record, we must recognize a functional equivalence control. This concept is central to the UCC Article 12 and UNIDROIT principles on detailed asset and private law. Control acts as a new possession. It is the legal method that creates perfection of security interest in detailed assets. Bringing this theoretical debate back to Korea, we confront the stark reality of Article 98 of the Korean Civil Code. Article 98 defines things strictly as corporeal objects or manageable natural forces such as electricity. Data assets fail this definition because data assets are not corporeal and they are not natural forces. The consequences are severe. Because these assets are not being, data assets are excluded from the Korean Act on security over movable assets and receivables, which the Korea enacted following the UNCITRAL model law on secure transactions. Thus, parties cannot register a security interest in these assets in the security registry because the registry mandate is limited to movable assets or receivables. Furthermore, since perfection of pledge requires possession, and one cannot possess these assets, the pledge mechanism is also unavailable. For this reason, lenders often rely on attaching the contractual right, which the debtor has against the data asset exchanges, treating the data asset as an not as an asset owned by the debtor, but as the debtor's contractual right against the data asset exchanges to return back the data asset or the price. This is a fragile legal fiction that fails completely for self-hosted hard wallets or cold wallets. This is incredibly risky. If the data asset exchange goes bankrupt, as we saw with global data asset exchanges like Mt. Gox or FTX, the user is not a secured creditor. The user has lost title and is regarded as merely an unsecured creditor, hoping for a fraction of the value. Next. So what is the path forward? I propose 3 pillars of reform. There are 3 critical issues of secured lending: perfection, identification or a specification of collateral, and enforcement. First, perfection. I suggest to incorporate the concept of control as a perfection method and to revive the Korean Act on security over movable asset and receivables, which Korea enacted following the UNCITRAL model law on secure transaction, to expand the scope of registration to include digital asset. Second, identification or specification of the collateral. Collateral should be specific for enforcement. However, because these assets are fungible, specification or identification is not simple. I think we could solve this problem through the cooperation with digital asset exchanges. By implementing freezing or attachment mechanism to specify the collateral digital asset in the digital asset exchange. I suggest the law should acknowledge freezing or attachment of the debtor's digital asset in the digital asset exchanges. Then the creditor may register the security interest in the debtor's digital asset with identifying or specifying the debtor's digital asset by freezing or attachment in the digital asset exchanges. Even on the Korean law, in practice, even on the current Korean law, in practice, attachment of debtor's claim against the digital asset exchange is procedurally possible. And third, in enforcement, under this arrangement, I suggest the court may order the digital asset exchanges to transfer the collateral digital asset directly from the debtor's account to the creditor's account as an enforcement when the debtor defaults. In conclusion, the global standard, the UCC Article 12 and the UNIDROIT principle on digital asset and private law are set. I think it is time for us to catch up. Thank you very much.
Thank you. I think I agree with Woo-Jung in the sense that more certainty and clarity probably would facilitate digital to asset trading. But I think also we should be careful that we don't over-regulate or actually block future technological developments. I think this is something that we need to bear in mind as we continue our discussions. With that, maybe I can pass over the floor to Megumi.
Thank you very much for Giuliano for the wonderful organization, and thank you for the thank you to Monica and Jay as well for the organization of the conference. I'm delighted to be here in Hong Kong in such a nice weather, and I'm very sorry that I'm talking about such a topic that doesn't give you, well, hopefully something of an interest to stay inside even though the outside is so nice. So digital assets, especially crypto assets, challenge our traditional tools of validity, publicity, and priority of secure transactions. Yet they are increasingly used as collateral for credit. Japan actually went through a secure transaction reform this year. We have a new law on non-possessory security interest for movables, including receivables, as well as retention of title. In a prior panel, Mr. Mizutani talked about enterprise value charge. That is a separate law actually that was passed last year. So we have had 2 major laws that passed on secure transaction this year and last year. So I'm going to try to talk about Japanese law and how digital asset might be treated as collateral. I'm taking a case in Japan on collateralization of digital asset. And then I'm going to talk about when and why exclusivity matters and why different digital assets may require different publicity priority mechanisms. So with that, let me begin with a concrete case in Japan. Sorry. Okay. Okay, I'm very bad at this. Okay. So if you take a look at this, I'm not going to go into a detail of this case, but there have been an increasing case of crypto lending in Japan. This one is a custody-based crypto lending. The lender is actually one of the biggest subsidiary of one of the biggest securities company in Japan. And essentially the borrower deposits BTC, Bitcoin or Ethereum to the exchange platform, which is the custodian. And then the debtor is essentially receiving a loan with that as a collateral. They generally get yen, so Japanese currency. The legal question here is this just a title transfer or is it a security interest? And how is it made effective against third party? In this scenario in Japan, as you can see in the last slide, the last line, security interest attached, let's say it's a security interest, attaches to an entitlement against the custodian. So it's not the actual blockchain itself that's collateral, at least in Japan, it's the entitlement against the custodian, which I think is similar in the Korean case as well. Actually, the new law that passed this year, because we are finally taking a functional approach to security interest, we call this kind of title transfer security interest Joto Tampo. So I'm going to refer to it as Joto Tampo, which is the Japanese term. This kind of lending will be considered as a security interest. So that sounds like a very good news, right? But the issue is, if we can go to this new slide. So on the left-hand side, you can see that, okay, formally now we recognize Joto Tampo, which says transfer security, and it's not just a transfer of ownership. So now if you create a valid Joto Tampo, the creditors will have the duties to return the surplus. There's the redemption upon satisfaction. What's my satisfaction? Or am I, something is wrong. Okay, so anyway, so it is a valid Joto Tampo. But the biggest issue is what the new law does not do is that there is no perfection method or no perfection system for crypto custody entitlement, because we do have a movable perfection method, which is possession or registry. If it's a movable, yeah, you can use that. But if it's not, then you will have to probably rely on registrable receivable. In Japan, the registry only allows registration of certain types of receivables. So this kind of entitlement to custodian may not or may, we're not clear yet because the new law does not have the clear definition of what will be the registrable receivable. It may or may not fall under this list, which means that if it doesn't fall under the registrable claim, then there is no way to perfect this. So you have, in fact, a valid security interest without a method to perfect. Yes, that seems to work perfectly well. And then on top of it, if the custodians have, or no, the customers have a claim against the custodian, then it could be receivable. But then if it's a segregated custody situation where you can actually maybe conceptualize property right, then it's not a claim or not a receivable anymore. So then you will have to think about what kind of perfection method this kind of property right will entail, will necessitate. So all in all, the perfection method in Japan is not clear. And that's going to be an issue in Japan. So what will happen for the model law on secure transaction? For now, yeah, I think the same will apply. Of course, the same case in Japan will be characterized as a security right. So that's no issue. The Model 1 secure transaction provides third-party effectiveness mechanism. Registration would kick in. So registration seems to be like a natural publicity tool for digital asset as well. But is it really so? For self-custody digital assets, so a digital asset that doesn't involve custodians, so self-custody, registration alone cannot secure exclusivity because these assets have no legal gatekeepers, right? There is no debtor, issuer, or custodians who can reflect the legal reality. So a registry may say lender A is secured, but nothing stops the asset from being transferred by someone who has technical control, and a third party may rely on that control instead. So this leads to directly a key idea. If control makes competing claims impossible, then control, not registration, can justify priority even without publicity, right? So that is what the double principle of UNIDROIT does. So I'm just going to very briefly refer to why exclusivity matters. So I think there are several reasons why exclusivity is important. First, enforcement reality. So only the party with exclusive operability can liquidate, right? That's very obvious. So the perfected creditors doesn't have control. They cannot really realize the value. Second, publicity can be misleading because I said before, there's no gatekeeper that can verify the reality. Third, as Woo-Jung mentioned, control is a substitute for possession, and possession has always been a publicity method for movables. So yes, if control can substitute possession, then why not have control as a publicity method? So that these reasons on top of the case that I have been referring to, in the case for Japan, borrowers cannot access the pledged crypto. So other creditors cannot seize it, right? So priority exists de facto, though not a perfected de jure. So that's the case. So I think the important issue here is if exclusivity is the essence of secured lending in digital assets, then we need to ask a simple question. How is exclusivity achieved in practice? For some digital assets, exclusivity can be achieved through a custodian or platform, which can block competing dispositions using technical control. For others, exclusivity is tied only to private keys held directly by the user with no intermediary. This means there is no one single control mechanism in digital assets. There are different sources of exclusivity depending on how the asset is held. And these two sources may require different third-party effectiveness rules or even different definitions of control. So the first step is to actually classify these crypto assets. So here I'm just taking an example, two types, custody-based digital assets controlled by the platform and self-custody digital assets controlled by the owner through private keys. So as you see on the list, I've just written down the features. So custody-based crypto, you will have entitlement versus custodian. For self-custody crypto, it's direct operability on blockchain. So this means that for liquidating, for custody-based crypto, it means that you need to have a custodian to act, right? And for self-custody crypto, you just need to have a private key. So here we see the biggest difference. So from then on, you can draw a conclusion. The publicity solution for first custody-based crypto, maybe registry might work, but another possibility is that there could be a control agreement. A control agreement between the custodian, customer, and the lender may work. So for self-custody crypto here, there has to be a legal recognition of factual control. So via control or the possession of the private key. So you already see the difference of what kind of control would work in different kinds of different kinds of digital assets. So these two are just a general examples. I think there could be other ways to classify crypto assets. So I think that classification needs to be really, really considered when we consider what kind of control can be achieved. So on the last slide, I'm just going to, I thought about this very late last night, so this is just something to begin discussion. But as I said, there could be custodial crypto, there could be self-custodial crypto. There's also DeFi assets involved. I think they would all require different kinds of ways to perfect. So for custodial crypto, maybe control agreement might work, self-custody control by exclusive keys. For DeFi assets, it would be a code-based control. So that would mean that you place the digital asset into a smart contract vault, which makes sure that debtor loses that control of that asset. So that's the way that DeFi assets in vault would probably work. And tokenized claim would be a totally different issue. So we'll have to try to decide in what scope the control perfection method would work. So there is a lot of things that needs to be considered when you consider about how control can work as a perfection method for secure transaction. So with that, I think I will just stop here. Thank you very much.
Thank you, Megumi. As lawyers, we like to define things, and I think we're now getting I'm getting a little bit confused about exclusivity, whether it's a feature of digital assets, whether it's a feature of secure transactions involving digital assets, or it is a feature of control, which are kind of all being mixed by the three presenters. I think we are using control in a slightly different way, and I think this is something that we need to clarify as well. With that, I think we're going to confuse you more with other transactions that are being used. And with that, Murat, are you with us?
Yes, Jay, can you hear me well?
Yes, please. You have the floor.
Well, thank you very much. And thanks to UNCITRAL, the Secretariat, you yourself, Jay, for managing this panel, as well as the Hong Kong Faculty of Law, and AIIFL for organizing this wonderful conference. I'm sorry that I cannot be there in person. I'm going to have to disagree with you at the start of my presentation, Jay, that this is not an academic panel because the three co-panelists are distinguished academics while I teach for fun. I will focus on what I call three trajectories in the digitalization of payment rights. The first one concerns some finance solutions that have been devised and are likely to be devised going forward, as we need to understand the mechanics of those solutions as well as the type of digital asset that is utilized to provide finance within those solutions. So I will focus on two types of finance solutions. The second trajectory concerns the domestic approaches that have already been taken in many jurisdictions, and I will limit my exploration to payment rights that may be incorporated in some type of a digital asset. And then finally, I will conclude with some observations on the different international standards that have been already adopted that to some extent deal with payment rights. I hope that this approach will enable us to assess what we can collectively do as a coordination network, but also in the broader context of the UNCITRAL model law to facilitate financing against payment rights. My preliminary conclusion is that we seem to be, all these trajectories seem to be headed in slightly different directions. There is a lack of convergence and uncoordination, just like within my favorite soccer team of FC Liverpool lately. So let's move on to the two finance solutions that I have selected for this presentation. Now, the first one is a BIS project, Dynamo. BIS stands for the Bank for International Settlements, and this project was executed in collaboration with the Hong Kong Monetary Authority. I wanted to highlight several aspects of this project, which are the following. So this finance scenario or solution utilizes or rather has been designed to facilitate the financing within what we generally refer to as supply chain, where we have multiple tiers of suppliers and eventually an anchor buyer that pays the money, and then the suppliers settle between themselves. So in this project conceived of this digital trade token, DTT, which is issued by a financial institution against a deposit of funds into a segregated account. So this DTT is not really a receivable as we know it. It's some type of a digital asset, and from its description and the features, it seems like a stable coin that is not used only to settle payment obligations, but also to finance the tiers of suppliers. And here are some of the features that I have listed on the slide, such as its accessibility only to verified users of Ethereum wallets. And eventually the DTT is used by dividing it among the tiers of suppliers that eventually settle with one another. The DTT, unlike, for instance, a negotiable instrument that we know very well, could be not only divided, unlike a negotiable instrument, but is typically paid against the satisfaction of time, data, and action conditions. So it could be, for instance, settled on satisfaction of certain ESG conditions. The next system, okay, so the next solution is what is known as the deep tier supply chain finance solution, which, for instance, the ADB published a couple of reports on. And essentially, the solution is designed to achieve the same objective as the previous solution, which is to facilitate the finance within a broader supply chain. This solution utilizes what is colloquially known as an irrevocable payment obligation or irrevocable payment undertaking. So the reference on the slide to IPO is not initial public offering. It's an irrevocable payment obligation that is issued by the anchor buyer. So unlike in the first scenario where the DTT is issued by a financial institution, this is a direct obligation of the anchor buyer. So this is not a stable coin-like feature. It's a completely different type of digital asset, which again cannot be characterized as a negotiable instrument for various reasons because of its characteristics. So these are the two. This is my first trajectory, which charts the direction of various finance solutions that are already designed and that have been already deployed that we should keep in mind when building any enabling framework on top of it or an international standard. Moving on to the second trajectory, which concerns domestic approaches. So we're not writing on a clean slate, so to speak. We, as you know, all international standards are taking into account what has been already done on the ground. And I'm providing examples of some domestic approaches that have already been taken to digitalizing payment rights. So of course, I'm going to start at the top with the UNCITRAL's very successful model law on electronic transferable records, the MLETR, which has been implemented by many states, including Singapore, to digitalize negotiable instruments, which is one of the main types of payment rights. The second approach has been taken, for instance, in China, and I will describe that on the following slide, where a patchwork of laws and regulations recognize account receivable electronic instruments. And this is not just a unique approach to China. This approach has been also taken, for instance, in Japan, that many years ago provided for electronic claims. The third approach has been taken in many jurisdictions in Latin America in terms of digitalizing invoices. So an invoice generally is a simple piece of paper that evidences some aspects of a transaction, but on its own, it doesn't have any intrinsic value. However, many laws in Latin America, such as Colombia and Peru, have been enacted for the purpose of collecting taxes. And through that vehicle, they digitalize electronic invoices and recognize them as negotiable instruments, which had been done previously by their commercial codes. So much of financing in these jurisdictions is done on an invoice by invoice, digital invoice by invoice basis. And just last week, I was speaking to our friend, John Wilson from the IFC, who described to me the great success of this type of financing in Colombia that unlocked a huge amount of liquidity where, unlike before, the lenders were quite reluctant to finance pools of receivables, but now they're quite comfortable with lending what seems to be an identifiable and exclusive object, which is a single receivable that is identified by registration. And then finally, all of us are, or most of us are familiar with the approach of UCC Article 12 with respect to controllable accounts that have been referred to by my co-panelists. So very briefly describing the situation in China that legislated for account receivable electronic instruments to address a significant problem where about a half of receivables are held in maturity, and those receivables, of course, cannot be financed for various reasons, including the risk profile of the debtor and obligor of the receivable. So RIs are generally or may be defined as unconditional promises to pay at maturity, whereby the debtor waives rights and defenses and is actually obligated to pay the money on this instrument, even if the underlying transaction or performance of its counterparty is defective. So even though it's denominated as an account receivable, but these features look more like or make it look like more as a negotiable instrument. One of the challenges, not only with this approach, but also in Latin America, is that no single law exists that comprehensively deals with all sorts of proprietary conflicts of law and contractual aspects of these new payment rights. So for instance, Article 11 of the revised regulations from 2025 confirms that only the holder of the claim, the holder of the IRI, can exercise the right represented by the certificate. But there are several issues that need to be addressed, and one of which, this is also common for negotiable invoices. What happens when a receivable has been transferred or sold before an IRI or a negotiable invoice is generated? So hypothetically, you could have a conflicting claim between someone who is a transferee of an underlying receivable and who holds an IRI or a negotiable invoice. Depending on the nature and the features, there's no uniformity in terms of the features and aspects of IRIs. They could be classified as receivables, instruments, or securities, which has not only very significant considerations and consequences for the application of the private law framework, given the gaps that exist in this legislation. The court would need to find whether they are one of these three types of assets to apply some legislation by analogy, but also for the regulatory treatment that was discussed on the preceding panel, where one institution may have a license to discount bills, such as negotiable instruments, but may not have a license to conduct factoring activities. So depending on the classification of IRI, a bill discounter may not be able to, because they may be classified as receivables. So that brings me to the final trajectory, that is the effect of international standards. And I will briefly summarize the 4 relevant international standards that deal with payment rights, starting out with the model law on secure transactions and the model law on factoring that essentially deal with receivables finance in the same way, clearly defining receivables and excluding other types of payment rights that are dealt with by way of separate asset-specific rules. Then we also have the UNIDROIT principles on digital assets, which to me were conceived for a different type of digital asset that we can colloquially refer to as a crypto asset. However, Principle 4 applies to what is defined as a linked asset. In other words, the digital record could be linked to another asset, such as a payment right, and the combination of two could create a linked asset that could be financed or transferred in transactions. And finally, we have the MLETR, which I have already referred to earlier, which digitalizes negotiable instruments. So we have international standards for receivables, for other types of payment rights excluded from the definitions of receivables, for linked assets, as well as for digital negotiable instruments. That brings me to my final slide, which leaves us with a number of questions. Well, Jay, you'll be happy to hear that I have not referred to control. I will not refer to control in my presentation at all. So what rules should apply to DTT, IPO, and other types of digital records and payment rights that may be devised in applications? And secondarily, should international standards cover domestic payment rights? In other words, are we even capable of providing some international guidance for those states, some of which I have already referred to on the preceding slides, and some of which might be taken some inspiration from these approaches taken in Latin America, China, but also Japan or US. So here I have listed just some examples of the challenge that we will be facing in revising or tweaking the international standards. The definition of negotiable instrument, which is the classic definition of a negotiable instrument, but at the end, it refers to the satisfaction of requirements under the law governing negotiable instruments. Well, as I have mentioned previously, the DTT and IPO includes all sorts of conditions that must be satisfied to trigger the payment. They are verifiable by smart contracts, and those conditions generally would exclude the application of negotiable instruments law, which are by definition unconditional obligations to pay. Then we have a definition of a receivable, which is a classic right to collect a monetary obligation, and we have built a corpus of rules for the collection of receivables. But the idea for a receivable is that receivable is not really a negotiable instrument. But all of these digital tokens or records that are used in these applications act like negotiable instruments. So there are some significant differences in the types of features that those new types of digital assets possess. And then finally, we have also a definition of linked asset that I have referred to, which may refer to or be connected to other tangible or, in our case, intangible right. But I would observe that DAPL wasn't devised as a legal instrument to enable the financing of payment rights. So we don't have the types of rules in the DAPL that would clarify what the obligation of the obligor is, or what are the rights and defenses of the parties to a classic transaction that relies on a receivable. So I'm leaving you with a number of questions that I don't have any answers to, but hopefully they help the Secretariat to build the list of questions for consideration of any expert group. What it seems to me, this is my final observation, is that we face an insurmountable challenge here, addressing the first two trajectories in terms of the types of finance solutions and the approaches taken in any type of an international standard, particularly the one that would provide or formulate certain rules for states to adopt. My preference would be to start out with a joint guide between UNCITRAL, UNIDROIT, and the Hague Conference that actually outlines and provides examples of some of these transactions and outlines some of these approaches taken in other jurisdictions to allow states to understand what the lay of the land is around the world in terms of international standard solutions and domestic approaches. So thank you very much for your attention.
Thank you. In light of all the questions that are being posed, I'm wondering whether a fundamental question is whether this area is subject to any harmonizations at this stage. I think this is probably where Marek was getting at. But also, I think Marek's point about states and parties actually faced with these kinds of transactions in their normal businesses, they need some sort of a guidance. And this is probably where we need to develop some sort of a guidance material on how this, giving a little bit more clarity. We have three professors who have their academic background and one professor who teaches for fun. So actually, I would open the floor for any questions that you may have so that we may actually get some answers from the professors so that they don't actually get to ask the questions, but answer them. Maybe JC, please.
Yeah, thank you very much. So in our discussions on tokenized assets and stable coins, which we're going to have a lot next year. So a central element is programmability through smart contracts. And that's critical for liquidity because it enables traditionally illiquid assets to be transformed into tradable digital tokens. It's also used in collateral management, for example, in enforcing specific collateralization ratios. So when collateral value falls below a specific threshold, then the smart contract can automatically trigger a liquidation mechanism that sells the collateral and repays the lender. But the big question is the legal certainty around smart contracts. So my question is, what is the current state of discussions internationally on whether smart contracts are legally enforceable and legally binding?
Let's collect some of the questions and then maybe I can pass the floor to our speakers. Any other questions? Giuliano, please.
Thank you very much. Thank you for all these four wonderful presentations. And I think, okay, so I'm going to be straightforward. Like, if we actually look at the market and see, for instance, that specific type of crypto assets that have been developing, such as stablecoin, such as a real world asset or tokenization, or other type of tokenization of securities, stocks and so forth. Do we want to establish international private law standards that are actually clarifying or somehow supporting these type of emerging assets? And it's a genuine question because, of course, we might not want international, from a private law standpoint, we might want something that is technologically neutral and stay a long time. But for instance, and I give just an example, neither the UNCITRAL model loan secure transactions nor the UNIDROIT digital asset principle say anything about the rights on reserve, for instance, on stable coins, because that's actually is a different things, as also Marek alluded. So yet the market is emerging to treat these type of stable coins as bank money. What private law should do, what international standards should do in your perspective? Should we enter in that area or be more general?
Other questions? Maybe if I may add on to what JC was saying, If we don't have clarity on the secure transaction side, what might happen is we may actually see a collapse of the market one day, and then insolvency law may actually jump in and then talk about enforcement and then actually solve the problem for the secure transactions. But I think that's a scenario that we don't want to see. And this is probably why we're actually trying to take a step forward. But with that, maybe I'll go the other way. So Marek, do you have any responses to the questions?
Yes, thank you for the questions. Both are very relevant questions, and I'm going to defer to the specialist on smart contracts on our panel, Teresa, for the first question. My view is limited to the specific scenario that the JC alluded to that concerns enforcement. So this is the enforcement of smart contracts is a general. He asked a general question. So it's a matter of primary contract law, but when it comes to enforcement of security rights in some digital asset, that is a question of a secure transactions law. And we have discussed this in the context of the UNIDROIT principles, whether automated enforcement should be recognized as enforceable or effective. We in fact drafted a partial principle on that, but after some discussion, we decided not to include it and instead provide some explanation whether automated enforcement should be recognized. And JC, that to me depends on the type of asset. If you have a crypto asset of the nature of Bitcoin or Ethereum, I think enforcement by way of a smart contract, automated enforcement should face less obstacles to validity because the interests of the parties are adequately protected, as opposed to a situation where a smart contract or other technological tool, for instance, freezes a piece of equipment that is in use at the time. So I don't have a general answer to your question, but my suggestion would be to analyze several aspects of a situation where the smart contract could be deployed. Now, as for Giuliano's question, which is very relevant as stablecoins have become very prominent in not only digital space, but also for the settlement and financing of transactions. So in my scenarios, especially the first one, that relies to some extent on the stablecoin is mainly a financing tool rather than a payment tool. So the kind of reserve that is made at the outset of the transaction, its main purpose is to be paid and to be settled eventually in the transaction. While if you use a stablecoin for simply payments, then you may have questions whether a person that holds the stablecoin is actually entitled to a reserve that sits somewhere in a custodial account. So these are, again, fundamental questions as to the structure of transactions and the uses of different types of digital assets that we need to look at first before we decide whether these questions are purely private law questions or they're hybrid questions or regulatory questions, as you know yourself very well, that the right to a reserve could be both private law and regulatory. So I'm going to leave it there, Jay.
Thank you. Megumi?
Thank you very much, JC and Giuliano, for the questions. I'm going to completely defer the question on smart contracts to Teresa for the international trend, and going to focus on Giuliano's question. I think my presentation essentially was about there needs to be a specific guidelines as to individual digital asset because they're so different. This probably goes against what we have been discussing yesterday, which was the trend in how international organizations create guides or any kind of instruments, which now tends to be that we determine the economic function or the result that we want to achieve, and that should be the guiding principle, or that should be the exact wording of the instruments, which is the functional approach and the technological neutrality. But I think in this instance, just taking the notion of control, there are just so many different types of transactions and so many different types of how digital assets are held, and that it seems just difficult to not get into the details of how this kind of control can be achieved, other than for the fact that we already have the DAPL principle stating how control should be the guiding notion in this case. We need to have more, if there is anything more to do with it, there needs to be a concrete examples and concrete understanding of what these specific types of digital asset and control works. And without doing so, I think it will just duplicate the work and may cause some difficulties for practice to really implement the rules. So I think that's where I stand. Thank you.
Thank you very much. With respect to the smart contract, I think as far as it is like contractual obligation, I think is effective, but I think the issue is whether the debtor, the current holder or owner of the data asset can unilaterally modify the smart contract. So if the debtor breaching the contract and unilaterally modify or revise the smart contract, and I think the creditor does not have a legal enforcement method. So unless the debtor breach the contract and revise the smart contract, I think the smart contracts would be effective. And with respect to the characteristics of for the second question about stablecoin and RWA, I personally think the approach of the UCC Article 12 is recommended. In United States, each state can resolute whether to adopt the UCC Article 12. I think up until now, about 23 states out of 50 states adopted the UCC Article 12. So it's kind of a model law, soft law. So the approach of UNIDROIT principle on data asset and private law is very good references for each state, each countries to enact their own act. Thank you very much.
So the last word is for Teresa.
Thank you very much for both questions. First, JC, I like very much your question about a smart contract in the performing, but also in the enforcing of security rights. So first, before going to the UNCITRAL model law on automated contracting, that is going to be, for me, the framework within we can find the international trend in this regard. The first point could be to which extent, if we think that the smart contract is representing or is coding the agreement between the parties, we could find situation of to which extent, for example, both parties have had access to the content that has been codified, to which extent there is a consent, to which extent this agreement that has been codified are properly in alignment with the agreement between the parties. And that could definitely impact on the existence and validity of that smart contract. The second level, I fully agree with Marek, that is not a problem of enforcement of the smart contract, but to which extent this self-enforcement, technology-enabled self-enforcement is in conformity with the specific rules for enforcement of that particular security interest. For example, if notice to the other creditors is needed, to which extent this notice has been properly, for instance, issued on time. So to which extent that enforcement is a proper law-compliant enforcement of that security. Now, what do we have in the international context? The UNCITRAL model law on automated contracting that was adopted last year, 2024, clearly clarified that a smart contract and even more automated contracting, so contract that has been concluded, negotiated, concluded, or performed by automated systems, AI agent, are valid and enforceable, including a particular provision that is talking about the fact that it's not in writing, but it's in code. And that concludes, in my opinion, the debate about to which extent a smart contract could raise obstacle for recognition in some jurisdiction because of the fact that it's in code instead of in writing, and therefore legible and comprehensible for the parties. So I would say that now we already have the clear pillars in the model law on automated contracting to guarantee that not only a smart contract, so purely deterministic, but also automated contract are guaranteed, and they are therefore enforceable and valid in the different jurisdictions following this trend. There is a professor here, Professor Feliu, who has written on a smart contract from a private law perspective. Maybe you would like to have some discussion with him. And very briefly, Giuliano, the point about to which extent we need private law when regulation is already solving certain problems. For me, this idea that we have 3 layers and they are mutually interdependent, I think that is absolutely fundamental, because if we simply rely on regulation, we're going to have a partial recognition, and in most of the cases, divergent. So if we rely on stable coins recognized in a particular country as money, and that is going to be priced in the Vienna Convention, for instance, we are making our private law dependent upon changing political policy-driven regulation, and in most of the cases, divergent among different jurisdictions. So I believe that private law has to be the foundation for regulation, and therefore we need to work on that. Thank you.
Thank you. With that, I would like to actually conclude the sessions. Please join me in thanking the speakers for their insights and all the interesting discussion.
Welcome to the last panel. I'm Queenie Wu. Thank you, the organizers, for having me. I'm the Deputy Director of Hong Kong International Legal Talent Office of Hong Kong Department of Justice. And in this panel, we have got 3 speakers. One will be joining us online. Hello, Anna.
Hello. Hello.
Hi. Hi, Anna. Anna Veneziano is the Deputy Secretary General of UNIDROIT. And in person, we have Mr. Danny Ang, the Managing Director of Seattle Law, and Mr. Richard Kohn, the founder and the principal of Commercial Finance Group, Gilbert Kohn Limited. Thanks. And today, before we move to the evolving practice of enforcement and intangible assets, I start with the AI search. The question I put in is, how is a secured transaction enforced? So a very, very brief, I assume that is the conventional, traditional way of putting enforcement of a secured transaction. The answer reads, a secured transaction is enforced after a debtor defaults by a creditor taking the collateral, either through a faster non-judicial process like repossession, or a slower judicial process like a lawsuit. After repossessing the collateral, the creditor can sell it to satisfy the debt. The specific methods for enforcement are detailed in some of the security agreements and or defined by law. I hope that would give us a very basic background of what we are going to talk about. And for evolving practice, I'm sure Anna can guide us through the UNIDROIT's best practice. Anna, shall we pass the floor to you?
Thank you. Thank you very much, first of all, Madam Chair, and good afternoon, ladies and gentlemen. I'm delighted to be here with you. Thank you to all the organizers, and in particular, of course, UNCITRAL and the Law Faculty of Hong Kong, and Giuliano Castellano for making this possible. Now, as you see from the title, which I hope you will see in a very short time when I start my presentation. Here it is. And as Queenie already said, this presentation will deal with the UNIDROIT project on best practices for effective enforcement. And it is true that sometimes legislators underestimate the importance of dealing with this phase of the execution of creditors' rights. But we know that it is often the stumbling block for an effective secure transactions law regime. So the project, which has already been mentioned in previous panels, is it's in final stage after the public consultation process, and we will be submitting the instrument to the Governing Council for approval by in a few days. Now, why is this project interesting for this conference and for this panel? Because though it has a much wider scope, it contains a separate part on enforcement of security rights, and it also contains a separate part on enforcement on digital assets. And I will try to touch upon both time permitting. Now, this slide is here just to show the methodology used by UNIDROIT in the development of the project, which is part of this coordination effort that it's tackled by the Secure Transaction Conference. The proposal comes from the World Bank Group. There is a participation of institutional observers, which are many of the organizations present in this room. And those organizations also facilitated the consultation phases. There was a first consultation phase at the beginning with practitioners facilitated by the ABRD, but we also had the public consultation phase from July to September 2025. Now, this is the structure of the whole project. As you see, it is divided in three parts. The first is on enforcement by way of authority, which is the default enforcement procedure. Queenie referred to those through public authorities. I'm not going to focus on those, though there are certain aspects which involve enforcement of security rights. And the second part is enforcement of security rights, focusing in particular on extrajudicial enforcement. And this was one of the concerns expressed in the proposal we received from the World Bank Group, and that's why we devoted a whole part on that. And then there is a third part on enforcement against digital assets. Why a separate part? Not so much because you have to look at the digital assets as a completely different animal than other assets, or that existing enforcement methodologies could not be used, but first of all, for visibility, legislators are now looking for some guidance. And secondly, because those existing measures and practices often have challenges in the case of enforcement, and those have to be discussed by and explained. So after dealing with the structure of the instrument, allow me to go to the part 2 of the instrument, which is the one on enforcement of security rights. And there are the two elements, the one, coordination with existing international instruments, and the other one, the added value of this particular instrument. So we know that for enforcement of security rights over movables in particular, the working group was not working on what was called a clean slate in terms of setting international best practice standards for enforcement. Existing international instruments approved at multilateral level already contained some guidance, and they were considered a point of reference. I'm referring, of course, to instruments by UNIDROIT itself, the Cape Town Convention and its protocols. This has a sectorial but important application, and the best practice is recognized that where there is a treaty obligation and legislation that it's passed domestically to adapt to the application of the treaty, this is something that it's a carve out on the general enforcement rules. But UNIDROIT also has, and it has been cited, the model law on factoring with rules on enforcement. And we also have our work on capital markets, which was relevant for this project. And we referred, of course, to the model law on secure transactions of UNCITRAL, the guide to enactment, and also the previous instrument, the legislative guide, which contained more narrative guidance referring to enforcement, and the more recent cooperation regarding the most recent toolkit on asset tracing recovery. Now, and recovery, sorry. So what is the added value of the best practice instrument? First of all, there is a different manner of presentation of the issues because this instrument is only devoted to enforcement. The best practices are addressed both to states that have enacted substantive secure transactions law, which are in line with international recommendations or already had that kind of system, but also to other states which may consider reforming enforcement practices following modern standards, but they might not yet otherwise have reformed their substantive secure transactions law to completely align with international standards. So the precedents we have are not rigid frameworks, at least for the method of presentation of the best practices in the area of enforcement. And since those are best practices, we had to strike a balance between sufficiently technical guidance, which is needed for procedural issues, but the need of flexibility. I think it was already said in previous panels that those international instruments can be used as a pattern, as a standard for legislators, but also as tools for interpretation of existing standards. And so that is also an added value. Now, we also have the integration of some of the guidance already provided in existing instruments with reference to UNIDROIT work. For example, there is a coverage of enforcement on intermediated securities. And we also have specific comments and illustrations focusing on enforcement, which will be helpful for legislators. Continuing on what this project adds to the international standards framework, there is a reference to the impact of technology on enforcement of security rights, and this was discussed also previously. The issue, for example, of automation for enforcement of security rights on rights to payment is at least touched upon. And there is also a reference to the online auctions, which are more specifically the sub-object of a recommendation in the first part of the instrument. The recommendations in the second part, in the part on enforcement of security rights, expressly refer to the advantages of considering online auctions for the disposition of collateral. And they also, in the comments, reflect on the potential impact of adopting such a method in evaluating the commercial reasonableness of the disposition. I think probably the most interesting part in the innovative character of the best practices is the next one. There is more detailed guidance implementing some general principles on enforcement that are contained in existing instruments. And I think the most interesting example in this case is the expeditious relief for extrajudicial enforcement. We all know that when a debtor raises an opposition to extrajudicial enforcement in many legal systems, what happens is that the extrajudicial enforcement is turned into a judicial one. And so this was a solution trying to find a better way to deal with these issues based on general principles already existing in international instruments. But I will not talk about this very important point because it will be the subject matter of what Richard Cohn in the following presentation will address. Finally, for part two, we have innovative guidance regarding enforcement of security rights on immovables. Now, here we know that all the international instruments we referred to do not address this issue. Accordingly, the recommendations in this part concerning enforcement of security rights in immovables are informed by practices in various legal systems. They are also informed in part by the international developments for the enforcement on movables, but they are innovative. And in the case of immovables, I would like to focus on two important points. The first is some modern regimes provide for enforcement both by way of public authority, but also extrajudicially. And such modern approach is reflected in the recommendations of this chapter, which extends principles regarding extrajudicial enforcement to immovables. I would also like to refer to the general principle of the World Bank in this respect. And the second point is there is a limited protection for so-called vulnerable debtors, for example, residential immovables or smallholder farmers, which tries to strike a balance and find solutions that do not block enforcement, but, for example, introduce short periods of stay or some kind of cooperation. Now, the last point I would like to address in the very last part of this presentation is enforcement on digital assets. Much has already been said on digital assets in general and also partly on enforcement. The part 3 of the best practices is mostly focusing on enforcement by way of authority, so through a public authority. And the main principle here is that digital assets should be susceptible to enforcement. This is also the principle 18 of the digital asset principles of UNIDROIT. But this works well if for the subcategory of digital assets, which are electronic records capable of being stored, of being controlled, with the control being defined in factual terms as in the DAPL principles, but this part does not exclude its application to other digital values, to the enforcement of other digital values, though it might be more difficult to use existing methods of enforcement for those values. And there is, however, a general recommendation in the general part, which is recommendation 37, dealing with these issues, so the enforcement by way of authority on intangibles other than the ones which are listed in previous recommendations. And there is a reference to data, for example. But it was felt by the working group that times were not ripe enough to find specific best practices in terms of procedures in this area. The last point I would like to address is the main recommendation of the part on enforcement on digital assets, which is the application of existing enforcement procedures and measures with necessary adaptations. So there are, of course, many challenges in the application of the usual enforcement procedures and measures. I think some of them have been already mentioned. The identification of the parties involved may be difficult or may require the cooperation of third parties. Even when the digital asset may be held by an identified holder, the transaction may be traced, but the public addressees may not always be connected to an identified party to the proceedings. And also, of course, location and identification, seizure and transfer of the asset may be difficult in practice. And this depends a lot, as was already said, on the holding models of the digital assets. So the 4 points here. First of all, there is an emphasis, this was already said in previous panels, on the cooperation, the duty of cooperation of debtors and also third parties, including custodians, and sanctions for non-cooperation. There is a reference to enforcement measures which are applicable to the debtor personally, which are available only as a last resource. For example, when the assistance of the debtor in providing the key or enabling the transfer or facilitating the taking of control over the digital asset is irreplaceable. They have to be applied proportionally and they have to be consistent with constitutional and treaty obligations. But because of the fact that even those impersonal measures can fail sometimes and become ineffective. For example, if the debtor is unknown, or against debtors lacking separate legal personality, or even because the debtor would like to cooperate but it's not in a position to do so, then other measures, there could be a combined use on enforcement measures in rem and in personam, and this may be particularly useful also for the case of linked assets, for example. I think there was a reference already to the possibility to use trusts or receivership for the enforcement of digital assets. This is something that is also mentioned. And finally, there are challenges addressed in the best practices for enforcement organs. And in particular, I would like to refer to two of these challenges. Enforcement authorities should have adequate technological and organizational systems to gain control, maintain custody, transfer or dispose of digital assets. Maybe this goes to the regulatory aspects that was discussed before. To ensure sufficient standards of reliability, safety, cybersecurity, but also guarantee separation of assets in custody and prevent unauthorized disposition or transfer. And then the final issue of liability, which may be also connected to the volatility of value. It's not just for digital assets, it could be also for other assets, but here it is a particular concern. So what is needed, the legislation to think about clear rules on the liability of enforcement agents for any action related to the seizure, custody, valuation and transfer or realization of digital assets, and maybe also limitations of such liability through various means. So I think I will stop here. I have gone 1 minute over my time. Sorry about that. And I will also stop sharing my screen. Thank you very much again for facilitating this presentation.
Thank you, Anna. We now invite Richard, who will talk about the expeditious relief supporting the extrajudicial enforcement under the UNIDROIT Best Practices Project.
Yes. I'm very honored to be here. I'm very well aware that we are the only thing standing between you and dinner. So I'm going to be alcohol. I'm going to be brief. But as Anna mentioned, I'm going to be focusing on one aspect of the UNIDROIT enforcement guide that I feel is quite exciting. I mean, enforcement is critical to security interests. The security interest has no value unless it can be enforced. And if you want to promote secured credit, one of the ways to do that is to have efficient enforcement mechanisms. They need to be balanced to give protections to the debtor and other affected parties, but they need to be also efficient so that a secured creditor who is considering extending credit can realize that it will have a good chance of realizing on the economic value of the collateral in the event of a default by the borrower. So one centerpiece of the enforcement guide, and it's also a centerpiece of the model law and many other modern secured transactions regimes, is the idea that a secured creditor has a choice of the ways in which to enforce. It can enforce judicially through a proceeding with a court or other authority, or it can proceed extrajudicially. And if the secured party agrees, elects to proceed extrajudicially, it's accorded great flexibility by these regimes in terms of the method, the manner, the time, the place, all of the aspects of the proposed disposition. And it may not be a public sale. It could be a private sale. If you're dealing with collateral that's intellectual property, it can be a license of that intellectual property if that's commercially reasonable in the minds, initially in the mind of the secured creditor. And of course, the flexibility is tempered by the fact that the actions of the secured party are subject to certain standards of conduct in the model law and in the enforcement guide.
Those are the standards of good faith and proceeding in a commercially reasonable manner. But what happens if the secured creditor decides to proceed extrajudicially and it's met with resistance? Perhaps resistance in getting possession of the collateral in order to effect a sale, or resistance in the sale itself. It could be resistance by the debtor or another affected party. The secured creditor can always abandon the non-judicial procedure, the extrajudicial procedure, and proceed with a court proceeding, but then you lose the benefit of the extrajudicial procedure. Alternatively, what happens if the secured party is acting in a manner that the debtor or another affected party feels is not commercially reasonable? Now, the model law deals with this to a certain extent. It provides two options, and this is in Article 74 of the model law. Option A deals with non-compliance by secured creditors. Option B deals with non-compliance by any party, and in each case, Article 74 suggests that there could be an expeditious procedure that could be resorted to allow the extrajudicial procedure to move forward, but that's as far as it goes. And the development in the enforcement guide that I want to talk about is Recommendation 120, which elaborates upon Article 74. It really builds on it by sort of fleshing out what that non-judicial procedure would look like. So I'm going to go into some depth in Recommendation 120, and I think it was a quite interesting discussion when we developed this recommendation, and I think it's important. The goal is to support the extrajudicial process. It's not an excuse for converting the extrajudicial process to a court proceeding. It can't be a backdoor to deprive the secured creditor of the right to conduct an extrajudicial proceeding. It's really an acknowledgement of the value of proceeding extrajudicially in terms of developing an enforcement scheme and promoting secured credit. It's not to be confused with an extrajudicial process, which the enforcement guide and the model law also contemplate, which is that if the secured creditor proceeds by judicial proceeding, there could be an expedited process for that as well. This is something totally different. This just supports the extrajudicial process, and it supports the entire process, including obtaining possession. Because if the secured party has the right to demand possession in order to conduct a sale or other disposition, and there's resistance, this process is available for that. And it calls for a concentrated, expeditious, and simple procedure. And by concentrated, the comments to Recommendation 120 make it clear that you're talking about, you have to resolve all the issues. It can't be piecemeal relief. The court needs to fashion a complete solution. And it's available to all the parties who feel their rights might be affected. Of course, it's available to the secured party, first and foremost, but it's also available to a debtor who feels that the non-judicial process is inappropriate for certain reasons. For example, the debtor might say, well, there's no debt. I paid the debt. Or there's no default. If the debtor argues that the secured creditor is not proceeding in a commercially reasonable manner, that's not a grounds for this procedure. That is usually handled by money damages. And the only time that the debtor could use this expeditious procedure for that is if it appeared with good evidence that the secured creditor was not in a position to respond with money damages, or that there would be some other irreparable harm by allowing the secured creditor to proceed. So I'm going to talk a little bit about the procedure for this expeditious proceeding. It begins with a notice to all the other parties, the debtor, all parties in possession of the collateral. And the only exceptions are if the goods are perishable, or there's a recognized market, or they threaten to decline quickly in value. These are the same kinds of exceptions you have for notice of a disposition in general, in both the model law and the enforcement guide. So basically notice to all parties, and then there's a description of what the court can do. The court can enter a court order trying to put the procedure back on track. The court can enter what's called a regulatory provisional measure, and that basically is defined as interim or provisional injunctive relief or proactive measures of some sort. And there is another recommendation in the guide, it's recommendation 73, that goes into greater detail as to what a regulatory provisional measure must do. I mean, for example, it should try to be consistent with what the court feels the ultimate result will be. There should be irreparable harm, a finding of irreparable harm, a finding that money damages can't compensate, a whole series of provisions dealing with standards for regulatory provisional measures. But the court can do a third thing. The court can also promote settlement, which I think is quite interesting. It can suggest arbitration or mediation as a way of getting the extrajudicial proceeding back on track. And the relief has to be granted within a short period of time. There's no guidance in recommendation 120 or the commentary as to what that period of time would be. It's within the context, it's for the court to determine, but the idea is they have to move quickly. And finally, I'm going to talk about some limitations on the court that are prescribed by recommendation 120. We've said this a number of times. It appears twice in the actual text of recommendation 120, but the relief has to support the extrajudicial process. It isn't an excuse for the court to take over the enforcement and convert an extrajudicial proceeding into a judicial proceeding. All relevant facts must be either undisputed or not credibly disputed or proven. So it's got to be, you can't have complicated factual issues that the court has to determine. But in most of these cases, there won't be complicated factual issues. They'll be rather straightforward. The order may be subject to conditions. The court can fashion conditions for the order in order to achieve a just result. I've already mentioned this. If it's a regulatory provisional measure, it must comply with recommendation 73 of the UNIDROIT enforcement guide. And the court has the power to enforce the relief it grants under recommendation 120. It can use the equivalent of contempt of court, whatever the equivalent of that is in the particular jurisdiction, in order to secure the proper administration of justice by requiring that its orders or regulatory provisional measures be enforced. And finally, it ends with this theme that's come up a number of times. In the enforcement of the order, the court cannot take over the proceeding, cannot take over the enforcement process. The whole concept of it is to put the non-judicial, the extrajudicial enforcement process back on track. I think this is a tremendous contribution to the field of enforcement law. I hope you agree with me. Thank you very much.
Thank you. Thank you, Richard, for telling us more about the recommendation 120 on how the court will support extrajudicial process, enforcement process. Danny, would you share with us?
Yes, I have the unfortunate task of keeping you excited at 6:10 and being in between yourself and gin and tonics or beer or whatever is your fancy. First of all, thank you very much, Giuliano and UNCITRAL, UNIDROIT, and Hong Kong U for having me here. I'm probably the exception in this crowd. I'm purely a practitioner. I don't pretend to be in any working group or associated with any university. But thank you very much. I do quite a lot of work on enforcement. I'm a litigator by profession, focusing in large part on enforcement, insolvencies and restructurings. Also a lot of work in digital assets. A lot of what I had intended to cover on my right here, this from Singapore, has actually been covered by Anna, Tessa, and Megumi and all that. But let me just streamline a few thoughts. I think the best practices guide that UNIDROIT has produced is tremendous. It's tremendous not only in the context of providing guidance, but if you go down to the commentaries and rules themselves, it is clearly very in-depth study of the challenges and the recognition of the challenges. And actually it coheres, in fact, with what we see in practice, the difficulties. I mean, starting with, effective enforcement, being dependent on recognition of digital assets being capable of being securitized. And if securitized, what kind of security? We talked about, well, pledge, out of the door, mortgage, out of the door. And Megumi say, hey, maybe it's about, and we talked about control and there's fierce debate about the notion of control. Megumi said, well, exclusivity, and so on and so forth. And all that is, while the issue is unresolved, it is actually very critical because the way the markets have developed is that in the last 5 years, I would say, in particular last 3 to 5 years, is when collateralization it has really picked up. And in fact, we all know that the regulators have been studying, tokenization of capital markets products, converting and creating value through collateralization of that. I have been speaking to the MAS about that as well in Singapore. But therein comes the next crypto winter or the digital assets winter, and insolvency and restructuring. And I think Jay had mentioned this. What then of the priorities, the recognition of the nature of security? And if we are, a point very validly raised by Megumi is, if we are stuck with this notion of control and the security is predicated on that. Sorry, let me backtrack. If we are following the case law in Korea and Japan, then all you have is a contractual right. And if you only ever have a contractual right, the whole notion that you have a security and a proprietary interest and priorities in insolvency is thrown out of the door, right? And I don't think in this world where these players operate, nor in fact, I would dare to say a lot of legal practitioners who are executing documentation upon documentation on securitization of digital assets, appreciate that. And I think guidelines and practices and guiding notes expanding on that, I think it's highly, highly valuable to the market. Coming back, I mean, that's on the insolvency distress side, but coming back to actual enforcement, what we do see, a point that has already been identified, identity. Because of this decentralized nature, identification of the custodian is critical. And it will come a point in time through your efforts and through your encouragement to borrowers and market players in the lending space, in favor of institutionalizing custodians, institutionalizing and using trustees, an independent party to custodize the secured assets. That is the ideal scenario, right? But quite often, that's not going to happen, particularly when we're talking about SME levels or even big players. And the assumption is that it sits nicely in the digital wallet, it's secure, and I've got a pledge over it or whatever collateral over it. When it gets not honored and you try to enforce, it's dissipated, we have to trace it. Ultimately, the point is that it goes into a private wallet and it's stuck there. So what do? You get a freezing order, but it doesn't get complied with, right? It's in personam, and the person might be in a particular jurisdiction that is averse and challenging to compel him to provide information. Then you think about receiverships, right? Whether receiverships pursuant to a debenture or the security instrument, or receivership pursuant to in aid of the freezing order, which is available in common law jurisdictions, they encounter the same problem. Their success and ability to enforce is entirely dependent upon information and access into the private wallet in that instance. The risks and the challenges have actually been very well recognized in the guidelines, in the best practice notes. But again, I think the awareness of that would then drive solutions towards institutional independent custodians. In the same way that you've got Bank of New York Mellon, who's typically a security trustee, and so on and so forth. But that concept is, I think, getting quite prevalent in the US. But outside of that, maybe a bit, and maybe in the EU, but outside of that, a bit less so. What is interesting, I picked up from the best practices guide, is the concept of good faith and commercial reasonableness, and you spoke a bit about that. I think just for the benefit of everyone, Rule 149 recommends various criterion and methods prescribed for valuing assets. That the valuation of the assets must reflect the characteristics, including volatility, lack of functioning market. Recommends also that where the market is available, the market be the referencing point. But what is good faith and commercially reasonable in the context of enforcement takes much prominence when we're talking about enforcing against digital assets where the values are hugely fluctuating. That's one. Liquidity varies tremendously. Also where, and this gets quite interesting, and we've seen it quite a lot in the, at least in the crypto world, where security holders, being the lenders, are themselves actually quite often seriously conflicted. And just because of the nature of the industry. So with significant fluctuations in value of the assets and market liquidity, what is a reasonable time, for example, to liquidate the assets becomes an issue. So your traditional duties of a mortgagee in the common law context is, again, not really applicable necessarily. Then we're going back into what, 1930s or 20s, where we're talking about fluctuations between the Swiss franc and the British pound, and how do you actually say that one acted in good faith reasonably when enforcing? And I think guidance or guidance along those lines and focusing on that would be quite useful. Or at least
some of that come with it with experience too. I mean,
yes,
the standards of commercial reasonableness and good faith have sort of evolved over the years, as as more and more cases are decided on that. And I think that the future case law with digital assets will contribute greatly to those questions of commercial reasonableness and good faith.
I think certainly, but I think in the context, I suppose, well, what I'm suggesting is that in the context of facilitating trade, I think guidance as to what factors to consider and just foreshadowing the issues that could crop up would be useful. The other is that, and I don't think it's been, and pardon me if it's been talked about, I've proceeded on the basis that, when we're talking about lending, it's in fiat, secured against digital asset pool. But what if we are lending in digital assets in USDC? Or let's not talk about it. We're lending in BTC, right? And secured against something else. And then the converse of the valuation issue arises, right? Because if I've liquidated that for 10 USD worth, but this on this side of the fence, your debt value fluctuates, then what happens? Again, I say this only in the context of highlighting that, you know, these are real world problems that I see coming in the next distress cycle and the default cycle. And actually, Rule 140 recognizes these challenges and suggests one possible solution for creditors is to satisfy the debt by taking control of the assets. I think that's a great suggestion, but it again, if the loan is denominated in inverted commas in digital assets, then it doesn't quite resolve that issue.
Some of these issues remind me of the issues you have when you're lending in different currencies.
Yes.
Or you're lending in, against in one currency against a borrowing base comprised of assets like receivables denominated in other currencies. And I think some of the same principles might end up applying.
It might. It might, and it will no doubt be tested during a distress scenario or distress times. Just more generally on enforcement, I think Rule 134, it emphasizes the duty of disclosure and cooperation of third parties. And I think in the context, a point I had alluded to earlier, in the context of digital assets, the speed by which we can compel information from the relevant exchange, third-party custodian, and so on and so forth is critical. So in normal circumstances, you would take enforcement action. You would have to examine the debtor, get orders for third parties, and by the time you get there, it's all gone 10 levels, 10 wallets down, right? And so I think, I would invite consideration in the context of digital assets to flip it the other way around. Before we even talk about it, starting enforcement action, the step one of the enforcement action actually is getting the information. Once you have that information, then with the speed, then, and the efficiency, we talked about expeditious enforcement mechanisms. In the context of digital assets, before we talk about gaining control, it would be securing the information as expeditiously as possible. The law enforcement has the ability to do that. They have their own network with the exchanges. But on the civil side, it is extremely challenging in terms of timing, in terms of speed. I have overstayed my welcome. Let me see if I've got anything else to add. Wish list, global register of third-party intermediaries, custodians, exchanges, subject to uniform rules and as to disclosure and cooperation, and subject to definitive rules as to disclosure of information. Yeah, I think that's it for me for now, Queenie. Thank you.
Thank you, Danny. Before I open the floor, may I ask the three speakers, what do you think of cross-border issues? How would the enforcement address the cross-border disputes?
Well, that's a fascinating issue because I think cross-border issues are of critical importance because in terms of not only promoting credit, but promoting the goals of organizations such as the United Nations, promotion of peace, cross-border transactions are essential because they enable parties in different countries to work together to develop understandings and to make the world a safer place, I believe. But it's a very complex issue. I mean, typically the rule is you look to the law of the forum for rules on enforcement and procedure. You might look to other law for substantive law. And that principle will probably carry over, I would think, to some extent, but it's going to get very complex.
Conflicts is a nightmare in the context of digital assets, particularly, because whether it's a subject to enforcement or not is up for debate in certain jurisdictions. We've just last week, for example, dealt with a counterparty that's in Belize, right? So I think coming back to my point, I think it's cross-border is not an issue if you're in jurisdictions which, are play by the rules and have standards that are, and that's why we're doing this work. You are doing this good work that you're doing. But there will always be the outcast jurisdictions or the jurisdictions who are attracting and trying to build up the economy by attracting these players. And I think that comes back to my suggestion, which is that if you have a gold standard in terms of licensed intermediaries and custodians and intermediated security providers, then increasingly that becomes, and it's made known that if you use these people, then then you're okay. And these people are in proper jurisdictions. And pardon me, I know in this forum we're not supposed to say things like that, but I'm not with UNCITRAL or UNIDROIT. But it is a practical challenge. Yeah.
Right. Anna, do you have anything to add on cross-border?
Yes, thank you very much. Well, for example, the instrument we have developed, the best practices for enforcement, do not address specifically issues of cross-border recognition and enforcement in this because there are also other instruments present, like for arbitration, the New York Convention, but we also have, of course, the HCCH, the Judgment Convention, and we also have the Singapore Convention itself for the settlement agreements. But this does not mean that there are no. It's actually quite interesting to see how this works, because as Richard said, once you have an enforceability of a decision or another act which was adopted abroad, then the enforcement rules that are applied are the ones of the domestic law. And so this is where we come in facilitating enforcement. So there are usually no special rules for foreign or internal decisions in this respect. So this is one point. The second point I wanted to raise is that this cross-border effect might be particularly interesting and difficult for measures such as freezing orders. We know that this happened, the extra national and cross-border effect has been recognized by some courts, but it has also been discussed in other jurisdictions. So there is a reference to that, a discussion to that, but it's not something where the best practices go in depth, but it is a question to be considered. And finally, I would think that in terms of conflict of laws, it depends, I think, very much on whether you have an automated enforcement system, which is under the realm of the autonomy of the parties. And there, of course, you could also have, as the UNIDROIT principles suggest, an element of the autonomy of the parties in deciding what is the law applicable to the digital assets. But if you have an enforcement through by way of authorities, or if you need a court order to compel, for example, the custodian to release information or to do something, then in the end you will be applying the procedure of that particular domestic law in any case.
Great, thanks. Okay, shall we now open the floor? Is there any questions for the panel? Yes, Teresa.
Thank you very much to all the panelists. I have a question related to this very interesting point of the global registry of intermediaries or custodian for two reasons. The first one, because it's very interesting to see how the use of digital assets that initially was a trend for decentralization. Now the only way to keep the market working in reliable standards is to have intermediaries that are reliable intermediaries. So this is a very interesting point that I think we have to bear in mind in order to decide the legal framework. And my second question, Danny, is to which extent you think that if we try to identify, even register these intermediaries, in a way we are regulating the market as a regulated market. And therefore we are back to this idea of only regulation is going to define, and private law, and therefore many custodians that are not performing activities that should be traditional regulated and supervised activities, because indeed these digital assets that they hold, they are not financial instruments, and however, they are subject to regulation type or regulation-like requirements. So to which extent you think that using this kind of mechanism is expanding too much or not the regulation types of tools to purely private law and non-regulated activities? Thank you.
I think the reality, commercial reality, is that organically and naturally, because of the drivers, the economic drivers, that the big players in the custody space will themselves be licensed just because of the nature of the services they provided, because it's trust services, escrow services. It's quite basic, right? So in all our jurisdictions where we're from, it would require a license, even if it's, you know, we call it light touch. So we're not regulating digital assets, we're regulating the service, which is already regulated. And I think, you know, the traditionalists or the crypto bros will say, oh, you know, this is inconsistent with decentralization and autonomous and all that. But then again, it was never meant to be securitized. It was never meant to be commoditized this way. And I, you know, the way I see it, at least you can't have it both ways. Yeah. But it is a wish list. It is a gift. As much as, and this goes far beyond even this suggestion, which is that the biggest challenge in enforcement for digital assets is private wallets. Because with private wallets, you're left with in personam enforcement. That's it, right? And is there a world one day where there is a secret register or private register of private wallets? Who knows?
I'm not responding to that point, but rather to Danny's point about who knows what the future will bring. I was sitting here thinking, you know, certain types of collateral, which UNIDROIT and UNCITRAL and the World Bank have focused on, like receivables, have been around forever. I mean, factoring went back to ancient Egypt and is still with us today. And digital assets are just in the last second of that time continuum. And who knows what we'll be talking about 10 years from now or 15 years from now in terms of collateral and enforcement of collateral. I just think we need to buckle our seatbelts. It's a very exciting time.
Thanks. I'm aware of the time. See if we have any other questions. If not, thanks Danny, thanks Richard, and thanks Anna.